Yes.
This is a very urgent matter which got left over. Justice services have been done. It's a matter of
Item number?
for item number 62. But there is also an IA
62.
62. No, not item number. Your Honor, I'm trying to mention this matter to be taken up either tomorrow or day after.
This is the second bench. You have
Uh,
to mention before the first bench. This is the second bench for matter. Bench for.
Actually, I was told that this is a matter of bench 4, and I'm quite new to the environment because I was
No,
in
bench
another
4. This is
country.
the second. There are two benches, madam. This is there is the senior bench. You have to
Number
mention there.
4. But I was told that I should be mentioning it here.
No, this is the second bench 4.
Same bench, but bench 4. Right.
Want to withdraw this?
Yes.
Madam? Why?
Your Lordship, because the engaged constable, Mr. MUP Ahmed, he has expired, Your Lordship. And moreover, the petitioner is a quite old person. He don't want to pursue with the matter.
You are S.
Nazneen. Yes.
S. Nazneen. Okay. MSS Nazneen, Learned Counsel. For the petitioner submits that there is instructions from the client not to press this application. Who's for the government? Mr. Sri G. Bokolia, Learned State Council. Does not object to the same. Said prayer. Full stop para. Writ petition accordingly still dismissed on withdrawal. First time.
No, Lordship.
First time.
No, it's third time. I'm
No, this application has been moved for the first time.
yes, sir.
It was
Lordship,
rejected earlier.
More than yes, more than
Rejected by your Lordship.
We'll
yes.
get the case records.
Lordship,
What is the stage?
Lordship, more than 1,000 days behind the bar since 2021.
What is the offense?
Yes, offense. Commercial quantity, Lord.
47 kg of ganja.
You want bail on the first day of commercial quantity. 1,000 days or 2,000 days, that is not the criteria. First, we'll have to have a look at the case diary. This has been rejected earlier.
Lord.
When can you get the, what is the stage? It is the stage of trial.
Yes, Lord.
Which court?
Yes, Court of District and Session Judge number 5, Kamrup and Guwahati.
Special judge.
Yes, Lord. It's District and Session.
Heard Miss T. Somlonatsun, who has filed this application under section 439 of the CRPC in connection with so and so. Full stop. The prayer for bail of the petitioner was earlier rejected by this court on 2 occasions.
Yes, Lord. Yes, Lord.
On 2 occasions. Full stop. Para. Let the case records be. Let scan copies of the case records be called for. Para. Registry to requisition the records of so and so case from the court of the additional district and session judge number 5, Kamrup. List on
15.
today is what? Today is 5th. Okay, 15th is, I think it's possible.
15.
On 18th.
18th
of March. Ms. So-and-so, Learned APP is present.
Deep. Deep. Yeah.
This is also earlier rejected. So up this is there.
Okay. Somebody has to press it.
No,
None appears for the petitioner on call. whereas Ms. Sunsu learned APP is present. Para, in the interest of justice, matter is adjourned to be listed on Friday next. Yes.
This is the petition against the judgment and award dated 39/2013 passed by the Thane Industrial Tribunal, my lord.
Okay.
Before my starting with the fact, my lord, one thing I just want to point out, my lord. This matter was substantially heard on 6/2, my lord.
Okay.
In fact, in the order it is reflected, but not as a part heard, my lord.
Okay.
And in fact, I have referred some judgment also. My
Okay.
learned friend, appearing on behalf of the SBI, was supposed to refer some judgment. On that ground, it was adjourned on that day, and
Yes.
on
correct.
27 to
Borgohain?
But the judgments are available.
Oh, no, his submission. I think it was heard at length.
yes, my lord.
Let it be heard.
On
with
last
the-
occasion, my lord, due to paucity of time, matter
Okay,
could not be
okay.
taken up, my lord.
Sri N.J. Khatunier, learned, heard Sri N.J. Khatunier, learned counsel for the petitioner, as well as Sri Buragohain,
H. Purago.
H. Buragohain, learned counsel representing the State Bank of India. Full stop. Para, at the outset, Sri Khatunier, the learned counsel, by referring to the order dated 6/2/2024, has submitted that this matter was substantially heard by a coordinate bench and was adjourned, and time was granted only to facilitate the learned counsel appearing for the bank to produce the relevant case laws. Full stop. Para. The aforesaid submission is endorsed by Sri Buragohain. Full stop. Para. In the interest of justice and for the sake of convenience, registry may list this case before the appropriate court.
Obla George.
Apply.
Yes.
But no, this is against an award caused by the labor court. Yes?
Hmm.
The impugn award is at page 19,
19.
19. Let me read out this award part.
You're for the employee union.
I'm for the union. This is against a lockout. A lockout was resorted to, and that lockout was subsequently referred whether this lockout is justified or not.
That is the issue of reference.
That is the issue of reference. Now,
Age?
page 19. For the India, got it?
Yes.
For the industrial dispute that arose between the management of Assam Carbon Products Limited and their workmen, the government of Assam filed notification dated 10 September 2008, referred the matter to this court for decision the following issue: whether the wages for the period of no work during strike of the lockout is admissible to the workmen. Subsequently, corrigendum was issued and more detailed terms of reference were spread. That you will also find at paragraph 2. On receipt of the notice, both the parties appeared before this court. The union, namely the Assam Carbon Workers and Employees Union, submitted a petition before this court that they will approach the appropriate government for modification of the issue. Accordingly, this court allowed time to bring modification of issue. Thereafter, the appropriate government issued a corrigendum on 7/3/2009, whereby it is notified, whereby it modified the issues as follows. Whether the workmen are entitled for wages during the period of strike from 27th November 2007 to 29th November 2007, and for the period of lockout from 29th November 2007 to 24th July 2008. So the basic issue was that whether there was a strike. And so for the lockout is concerned, it is an admitted position. The lockout was resorted by the management. Now, our first question before your lordship would be whether the union resorted any strike or not. And we have to examine this issue in the light of the definition of strike as described in the Industrial
Tribunal. Act.
Industrial
Industrial Tribunal
Dispute
Act
Act.
1947. Yes.
Hmm.
I think we can read the award first.
Oh, let us.
Then
That
it
will be
will
better.
better.
Both the parties filed their respective written statement and additional written statement. The pleaded case of the union is that Assam Carbon Products Limited was established in the year 1963. There were more than 300 employees in the company, and all were regular employees. In the month of September 2007, for the first time, the management decided to engage contract labor in the company. No, that's all. Okay, not good.
Side to delay হল না এখানে এনেকে delete বুঝি কিয় না এখানে সব পারো না মানে আছে কিয় না থাকিব সদায় লৈ থাকো Industrial Disputes Act 1947.
Extra 90.
No, we have at least 2 copies.
No problem.
Disputes are take over, deed take over, right? Not only. একটু say দেবে হবে এটা তলব না না ঠিক আছে ইন্ডাস্ট্রিয়াল ডিসপিউটস অ্যাক্ট দেখা কিতাপ বিচাৰি নকৰ কথা নহয় দেই কোনো কথা কিতাপ কিয় বিচাৰি নাপায় Yes.
Page 20, paragraph 4. The pleaded case of the union is that the Assam Carbon Products Limited was established in the year 1963. There were more than 300 employees in the company, and all were regular employees. In the month of September 2007, for the first time, the management decided to engage contract labor in the company. The union strongly protested this unfair action of the management. However, at the intervention of Assistant Labor Commissioner, the union withdrew its protest. Thereafter, the management began to increase its production target from time to time without filling up the vacant post caused due to retirement of the employees as well as the workers. The union raised this point to the management with a request to appoint some new persons in places where the vacancy caused due to retirement of the employees. But the management refused to fill up the vacant post on the ground that the workload imposed on each worker is less than the norm set up by the National Productivity Council and insisted the workers for increase of workload. It was the stand of the management that if the prevailing workload is not increased, they would not disburse the bonus to its workers and the employees. In these circumstances, the union considered to increase the load of work thrust upon each worker, and an agreement was executed in this regard. Only after signing of the agreement, the management disbursed bonus to its employees. The management again started engagement of contract laborers in various sections where the vacancy arose due to the retirement of regular employees. The union strongly protested it, but the management did not pay any heed. Finding no other alternative, the union resolved in its executive body meeting held on 23/11/2007 that the workers should protest without protest forthwith if the management continues to engage contract laborers other than clean areas. The decision was duly communicated to the management, but the management was adamant to engage contract laborers in violation of their earlier assurance and instruction of Assistant Labor Commissioner. In such situation, union was compelled to take the path of agitation. That may kindly be noted. Whether this agitational path amounts to strike or not, that is the basic issue that is to be discussed by your lordship. That is to deal with the lordship in view of the definition as contained in Section 2K of the Industrial Dispute Act. Whether there is a cessation of the work or not, whether it amounts to strike or not. If this strike is defined, Section 2Q, strike means a cessation of work by a body of persons employed in any industry acting in combination or a concerted refusal under a common understanding of any number of persons who are or have been so employed to continue to work to accept the employment.
Yes.
Some educational program was resorted to, whether this educational program amounts to strike or not. That has to be dealt with your lordship. This is the basic issue what I will before all. Then the management lost false allegation before the labor officer cum conciliation officer that the union was resorting strike action. Based on this allegation, the labor officer cum conciliation officer initiated a conciliation proceeding. The management ignored the conciliation proceeding and declared lockout of the establishment from 2:30 a.m. on 29/11/2007. The union contended that the notice of lockout was as well as the genuine reason was for contended that the notice of lockout was as well as genuine reason. The lockout was illegal, and therefore the union raised the demand to pay full back wages for a period of lockout. So union contention was twofold, that the
What was the agitation program you had undertaken?
some additional program because of the introduction of the work.
No, what was the nature of the agitation?
Putting black badge and shouting slogans outside the work premises.
Did this come in the evidence?
Yes,
There was no cessation of work.
there is no cessation of work. Their contention was that we are resorted to go slow. That was their contention. So they had to establish that the production was reduced because of resorting go slow.
Now, how do you differentiate between the phraseology go slow and a strike where there is a cessation of work?
Yes.
What is the distinguishing factor?
Cessation of work. No, cessation of work.
Cessation of work on one hand and go slow on the other hand.
Other hand. So for the go slow is concerned, burden lies on them. That
Now,
they have to-
will go slow per se mean cessation of work?
according to them. Yes, go slow may amount to cessation of work. So there is some certain target of product, and we have not fulfilled that.
Cessation of work in common parlance means there has to be a stoppage of work.
Yes.
The stop.
It may be full stoppage or partial
A
stoppage.
cessation means stoppage.
Hmm.
There is no activity.
There is no activity.
No activity.
No activity.
Go slow means yes, there are activities, but with interruption. Maybe we will not work full hours.
Full,
We'll
so we have worked
1
full-
hour will agitate, 1 hour will do. That may amount to go slow. Okay.
or
We'll
deliberately we have resorted go slow to reduce the production.
the amount of effort which is normally given, that is not given.
That
So
is not-
ultimately production is affected. That is the ultimate go slow.
Go slow.
Okay.
Yes.
Okay.
Path of agitation. Then the management lost false allegation before the labor officer come conciliation officer that the union was resorting strike, etc. Based on this allegation, the labor officer come conciliation officer initiated a conciliation proceeding.
Hmm.
The management ignored the conciliation proceeding and declared lockout of the establishment from 2:30 a.m. to 29/11/2007. The union contended that notice of lockout as well as the genuine reason. The lockout was illegal, and therefore the union raised a demand to pay full wages for the period of lockout. Now, paragraph 5. The pleaded case of the management is that union and the workmen tried to impose their authority in running the factory. They raised objection each and every decision of the management, including the recruitment of managerial staff. From the month of July 2007, the union and the workmen adopted go slow. That is the basic function. Union and the workmen adopted go slow tactics, refused to perform duties properly. These acts of union and the workmen affected the production of the factory. That is the basic allegation against the union and their members who are the workers of the sector. The management issues various letters, public notices to the union and the workmen resorting normalcy in the factory. There was a complete breakdown of operation from 25/9/2007 when the union raised violence at the factory and threatened the management staff with dire consequences. Due to lawlessness created by the workmen in the factory, the management compelled to write to the officer in charge Nunmati police station But the union and the workmen continued their illegal act. They demanded that the study should be conducted by the National Productivity Council, NPC, for activity at the capability and the capabilities of the machine and the productivity at the factory. Accordingly, NPC study was conducted and the factory in presence of the workmen, at the factory in presence of the workmen. But before implementation of the report of the National Productivity Council, NPC, at the instigations of the union, few workers started lawlessness inside the factory. Apart from regular disturbances, mass absenteeism, and threatening to the management staff go slow tactics. The union resorted to, that is
Just a
important.
minute, just a minute. Yes. Yes,
The union resorted to lightening illegal strike on 27/11/2007. In contravention of Section 23 of the Industrial Dispute Act. To save the management staff, plant and machineries of the company, the management compelled to declare lockout with effect from 29/11/2007. The management contended the lockout declared in consequence of illegal strike. Their contention is that we have resorted to an illegal strike, so they had no other option but to resort lockout. Lockout declared in consequence of an illegal strike shall not be deemed to be illegal. So according to them, as the strike itself is illegal, so their action of lockout shall not be deemed to be an illegal. The lockout was withdrawn with effect from 25/7/2008 in pursuance of a tripartite settlement dated 23/7/2008, arrived at between the Labor Commissioner, some conciliation officer, the management and the union. A tripartite settlement was agreed that the wages for the period of strike and lockout period, no work, no pay, would apply. Such question of wages for the period of strike and lockout, it does not arise. That is not the correct contention here. And what happened during the period of lockout, they formed another, at the instance of the management, and another union was formed. And with that union, a tripartite settlement was made. That was a management-sponsored union.
tripartite means who is the third party?
Third party is the government at the instance of the Labor Department and the new union and the management. In this type, now for the timing letters, I will let you refer. The one of the contention, one of the condition of the tripartite settlement,
Yes,
which was arrived on, that is probably Exhibit 42. Yes, Exhibit 42. Now, your lordship, just make a note for that, my lord.
yes.
For the tripartite settlement, there is a clause 4. I will refer subsequently.
Okay.
That clause contains on wages of alleged illegal strike / lockout period. It was agreed that the principle of no work, no pay would apply. This apply. However, the strike and lockout However, the strike and lockout is justified, oblique unjustified, legal or illegal, being disputed between the parties. The matter intended by them before to be referred for further adjudication to the appropriate authorities. So there was a settlement. By virtue of that settlement, the lockout was lifted. But so far, the period wages during this period of lockout, that could be adjudicated by the appropriate one. If that is that. And in accordance with that settlement, we has done investigation. Now our contention is that the lockout, resorted lockout was illegal. And on the basis of our contention, the dispute was referred and subsequently corrigendum was issued. And in this corrigendum, more detailed terms of reference was.
So there is no bar under 18.
No, there is no bar under it.
Okay.
That is what is my point.
Okay.
Got the point. There is no bar under 18 because the
Because
matter.
the tripartite settlement itself left a window open to raise this issue before the appropriate court, which you have done by the
Raising an industrial.
by the raising an industrial disputes, and reference was initially made on one issue, modified later on.
By corrigendum.
Okay.
So section 18 will not
No,
operate.
not
here.
nice.
That is my content, much of that. The management contended that lockout declared in consequence of an illegal strike shall not be deemed to be illegal. The lockout was withdrawn with effect from 25/7/2008 in pursuance of a tripartite settlement dated 23/7/2008, arrived at between the Labor Commissioner cum Conciliation Officer and the management and the union. In the tripartite settlement, it was agreed that the wages for the period of strike and lockout of the principles of no work, no pay would apply. As such, the question of wages for the period of strike or lockout does not arise. That is the contention of the management.
Let us see that clause again, where this
Yes.
contention is based on a particular clause.
Yes, sir, that is clause 4. Yeah.
Is it a part of this, of your?
It is in the part of the report, material and law.
Petition?
This settlement was exhibited by the management.
Is it a part of the writ petition, or we need to look at the records? We can have records are here.
Part of it.
No, is it annexed with the writ petition?
No, it is not.
Original records.
Exhibit 42.
Original report.
That is an evidence by way affidavit on behalf of the management, MW1 or Assam Carbon Products Limited. From Basanto Kumar Saikia, MW1.
Evidence, yes.
Internal page is 163. I don't know what is the page here. Exhibit 42.
Exhibit 42.
2.
Yes, we have a clause.
Clause. Clause 4.
Clause 4. strike and lockout.
On wages for alleged defined terms were settled with regard to the contract labor, with regard to the casual worker. So for casual work,
Let us read clause 4
class 4, let us read.
on wages.
Huh?
On clause 4 on wages alleged.
Yes, on wages for alleged illegal strike, lockout period.
Yes.
It was agreed that the principle of no work, no pay would apply, full stop.
Yes.
However, the strike and lockout is justified, unjustified, legal or illegal, being disputed between the parties. The matter was intended by them to be referred for further adjudication to the appropriate authority. A strike may be justified or unjustified. A strike may be illegal or legal. Even a legal strike may be unjustified. That is defined issue. So there was a clause.
Yes.
Pursuant to that clause, an industrial dispute was raised, and that was referred to the labor court, and labor court adjudicated this matter, and an award was passed in their favor. According to them, we resorted to a illegal strike, so the management has a right to resolve lockout.
Yes.
In support of their respective contention, both the parties adduced evidence before this court. I have heard argument advanced by Mr. S.N. Sharma, learned senior advocate for the management, and Mr. Sarveshwar Das, learned advocate for the workmen union. Peruse the pleading and the evidence on record, peruse the written argument. The management witness number 1, namely Sri Basant Kumar Shaitya, the then Deputy Manager, Personal IR of Assam Carbon Products Limited, in his evidence stated the workmen were in habit of interfere with the management function, and in fact always tried to impose their authority in running the factory. From month of July 2007, the workmen, at the instigation of the union, adopted go-slow activities. That is the main element. Refused to perform their duties properly. Go-slow and refused to perform their duties properly, which affected the operation of the factory as well as the loss in production. So burden lies on them to establish this fact that we resorted close and we refused to work in terms of the duties, and thereby they suffered loss in production.
Yes.
The union also demanded, suggested a study be conducted for arriving at the capability of the machine and the productivity at the factory at Birkuchi. The management accepted the suggestion, and accordingly an NPC study was conducted at the factory in presence of workmen. After conclusion of the study, a meeting was held on 4/8/2007 in presence of the president of the union a report of the work study NPC Exhibit 6 was furnished on that day. From the report, it had come to that the machines of the factory were underutilized by the production, underutilized by, and the production ought to have been doubled than the production made by the workers till date. Accordingly, by later dated 25/8/2007, Exhibit 7, the management requested the President of the Union to advise the members to work towards the full implementation of the recommendation of NPC. But the workers at the instigation of the union refused to raise production as per NPC norm and started to go slow tactics, which had lowered the productivity of the factory. They also started non-cooperative attitude with the management. Though the management wanted bilateral discussion with the workmen, the union prevented the workmen in attending such bilateral discussion. In view of the above, the management issued various notices. Those notices are exhibited at Exhibit 9, 10, 11, 12, 13, 12 and 13 to the union requesting the workmen to stop go slow. According to them, we have resorted our go slow tactics, and so they issued several notice requesting them to resort to stop the go slow tactics. To stop go slow and to raise productivity, but in vain. Due to lawlessness and go slow tactics adopted by the workmen, along with the abstentionism, and the company suffered huge loss, and hence to save the company, the management thought of engaging contractual labor. So the work which were performed by the regular workers, they decided to introduce contractual labor in place of the regular employee, so that the production may be enhanced as per their desire. That's it. The company suffered huge loss, and hence to save the company, the management thought of engaging contractual laborers in the factory, and accordingly got itself registered under the Contract Labor Regulation and Abolition Act 1970. So in order to engage some contract labor, the management should obtain a license from the authorities of the Contract Labor Regulations, and they obtained that license. Exhibit 14 is the registration certificate dated such and such. By the aforesaid registration, the authority allowed the management to engage 50 contract laborers in the process of manufacturing, loading, unloading, and other works. Further, MW1 stated, in pursuance of the registration of the management under Contract Labor Regulation and Abolition Act 1970, the management decided to engage contract laborers, partially at the clean section. In this regard, the general manager held a discussion with the union on 25/9/2007. But the workmen of the factory went to a lightning strike and formed an unlawful assembly informed the clean area and started abusing the management staff by using slang, unparliamentary words. Some workers hurled stones and bricks towards the clean area. They also threatened the management staff to burn them alive. And under such circumstances, all the management staff felt insecurity inside the factory, for which the management had to take help of police. On 13/10/2007, both the parties arrived at a settlement. Exhibit 21 is the memorandum of settlement signed by the parties. By the state settlement, the workmen represented by the union agreed to implement all recommendations contained in the report of NPC. Even after this settlement, the union and workers again started their educational program and thereby violated the terms and conditions of the settlement. Then the management informed the whole issue to the Assistant Labor Commissioner by its letter dated 21/11/2007, Exhibit 24, and 23/11/2007, Exhibit 25, and requested the authority to direct the union to comply with the settlement. In pursuant to the aforesaid complaint, the labor officer filed his letter dated 23/11/2007, directed the union to refrain from illegal activities. According to the labor officers, that we resorted some illegal activities, and the labor officer advised us to refrain from those activities. That is Exhibit 7. Directed the union to refrain from illegal activities and to call off all sorts of agitational parts. Whether these additional parts amounts to strike or not, that is to get this. To refrain from illegal activities and to call off all and sorts of agitational paths. Even after receipt of the same letter of labor's officer, the workman, in violation of the terms of the settlement, has illegally went on lightning strike from 9:45 a.m. of 27/11/2007. The general manager immediately issued a notice, Exhibit 27, which copies to the Assistant Labor Commissioner, President of the Union, and to the notice board requested the workers to desist from such illegal strike. MW1 himself, by Exhibit 21, wrote to the Assistant Labor Commissioner about the lightning strike resorted by the workers. The President of the Union and the notice board requested the workers to desist from such illegal strike. MW1 himself, at Exhibit 8, wrote the Assistant Labor Commissioner about the lightning strike resorted by the workers. The labor officer immediately on 27/11/2007 wrote a letter, Exhibit 29, to the General Secretary to call off such agitational program. But the union and the workers did not listen to anybody and continued with their illegal strike. So this, according to them, this agitational program amounts to illegal strike. But the union and the worker did not listen to anybody and continued with illegal strike. In view of that, a letter dated 28/11/2007, Exhibit 30, issued to the President of the Union to withdraw their illegal strike. And also inform him that since the action of the union is in violation of the Section 23 of the Industrial Dispute Act, your Lordship may kindly make a note with regard to the Section 23. I will later address them. Section 23 of the Industrial Dispute Act, the management may have to take appropriate action. In spite of the receiving that letter, the workmen did not stop their illegal strike. Due to a continuation of the illegal strike and due to get the apprehension about the safety and security of the management personnel, as well as the plant and machineries of the factory, the management declared lockout. The union remains adamant for normalizing non-situation. Then the general manager of the company, by letter dated 2014/2008, Exhibit 36, addressed to the Assistant Labor Commissioner, and by letter dated 17/1/2008, addressed to the Honorable Minister, Labor and Employment, with the copies of the Commissioner, among the union evidence. copies of the commissioner and special secretary of the labor department informed of the uncertain industrial climate of the factory. In the meantime, the general secretary of the union sent a letter to the labor officer alleging non-payment of earned wages and illegal lockout. That we raise an industrial dispute. And on the basis of the said letter, conciliation parley was held in the office of the labor commissioner on 28/3/2008, 29/3/2008, and 6/4/2008. But no settlement could be reached between the parties. Thereafter, Lord, this is very much important. Here, Lord, may kindly take note of it. Thereafter, a new union of the workers was formed. During the pendency of a lockout or the strike, whether forming of the new union is an unfair labor practice or not, that aspect has to be considered by your lordship. Because Schedule 5 of the Industrial Disputes Act give an illustration of the unfair labor practice. And this is one of the unfair labor practice, that is sponsoring of a management sponsor, making a settlement with the management sponsored union is also an unfair labor practice. That too during the strike or the lockout. That will, I shall place it later subsequently. Your Lord may kindly take it about the fifth schedule of the Industrial Dispute Act. Thereafter, a new union of workers was formed, which was also registered trade union. The said union, by letter dated 21/6/2008, Exhibit 40, requested the Commissioner and Special Secretary, Labor and Employment Department, Government of Assam, with a copy to the management for discussion with the matter with them. Accordingly, the Labor Commissioner from Conciliation Officer issued fresh notice of conciliation, fixing day 23/7/2008. On that day, all the parties attended the office of the Labor Commissioner. The old union refused to, old union means our union. The old union
What
refused,
is the new union called? How does it call itself?
name of the new union.
Okay, we'll come to that later. Madam, just try to find out. Okay, we'll come to that later, Mr. Das.
Name of the union, no?
Because you are trying to carve out a distinction between the original union and a new union which is formed at the instance of the management. That is your
Management.
allegation.
During
the
the
ma-
pendency of the lockout.
Lockout.
And this settlement was arrived between the new union and the management. And it was a tripartite settlement, conciliatory settlement. And there is a clause that the every party may approach to the appropriate forum for examining whether the lockout or strike is legal or illegal. So I'm giving just an effect on.
Doesn't matter, we'll have it later. You can please continue.
Thereafter, the new union of the workers was formed, which was also registered trade union. The same union, by later dated. No?
Assam Carbon.
Assam Carbon Staff and Workers Union, Bhilkuchi, affiliated to INTUC. Your lot will find at page 160. Exhibit 40.
40.
Exhibit 40. The new name of the union is Assam Carbon Staff and Workers Union, Bhilkuchi, Guwahati, affiliated to INTUC. Exhibit 40. Your lot will find at exhibit page 160. new union formed, which was registered trade union. The state union, by their letter dated 21/6/2008, Exhibit 40, requested the commissioner and the special secretary, Labor and Employment Department, Government of Assam, with a copy to the management for discussion with the matter, on the matter with them. Accordingly, the Labor Commissioner cum Conciliation Officer issued press notice of conciliation, fixing the date on 23/7/2008. On that day, the parties attended the office of the Labor Commissioner. The old union refused to participate in the discussion, but the new union insisted for conciliation. After much negotiation in presence of the conciliation officer, a settlement was arrived at, and the tripartite agreement was signed on that day. By the state agreement, it was agreed for the period of strike lockout, no work, no pay would apply. Pursuant to the state tripartite settlement, the lockout was lifted on 25/7. Here, the learned presiding officer probably failed to look into the clause 4 of the settlement. And probably he failed to appreciate, or he could not apply his mind to that effect, is my presumption. Pursuant to the state bipartite settlement, the lockout was lifted on 25/7/2008. Okay. MW2, C.K. Joshi, the Assistant General Manager Accounts of the factory, his evidence is alike with the evidence of MW1, and he supported the MW1 on all material facts. By cross-examining the witnesses, the union could not elicit anything in their favor. I will read the NW1 first evidence. The union examined only one witness, namely C. Govinda Kalita, who was the president of the union. In his evidence, he stated that workers never resorted to strike or stoppage of work. That is our full context.
Yes.
They only protested against the management of contract labor, engagement against the engagement of contract labor in the factory. That was our full protest against the management to engage contract labor in the factory. While the workers were in third shift on 29/1/2007, the management declared lockout. That was about the 2 p.m. at night 2 a.m. The management declared lockout. Further, he stated that during conciliation proceeding, the management declared lockout, and as such, the lockout was illegal. According to us, the lockout was declared in course of the conciliation proceeding. So it is by section 23.
23.
Huh?
23.
23
The
and
prohibition.
23 as well as 24. So it should be declared as an illegal lockout. According to them, no conciliation proceeding was initiated on that day. So the question of illegal lockout does not arise. That is the contention of the management. Only conciliation officer desired that both the parties should come to him for an amicable discussion. But according to them, no conciliation proceeding was initiated. And so as there was no conciliation proceeding, they had the right to resolve lockout. In cross-examination, these witnesses admitted that at the time of appointment of junior engineer and other officers by the management, the union raised objection. He admitted about the NPC study made in the factory. He also admitted receiving letter dated 23/11/2007. That is a letter issued by the conciliation officer. Exhibit 26 issued by the labor officer asking them to call off their strike. So the labor officer requested us to call off their strike and wrote a letter. Whether that amounts to an initiation of constellation of proceeding or not, that has to be examined by Kellogg. According to that, then this is not an initiation of constellation proceeding. This is simply request made by the constellation officer. So for that purpose, my lord, I have to go through the provisions of section 12, letter. He admitted that the tripartite settlement dated 23/7/2008, that is Exhibit 42. From the above written statement and the evidence of both sides, let me decide whether the workmen are entitled to wages for the period of strike, for the period of lockout, and for the period of lockout. The union's first contention is that during conciliation proceeding, the management declared lockout, and such lockout is illegal. Lockout was illegal. But they failed to show any document that during the relevant period, any conciliation proceeding was pending before the conciliation officer. But according to them, whether this letter, which was issued by the labor officer on 23/11/2007, Exhibit 26, whether this letter whether this letter amounts to initiation of the conciliation proceeding or not. If it is initiation of conciliation, if it is not initiation of conciliation proceeding, they have a right to resolve their lockup. Labor commissioner, labor officer directed us not to resolve any lockup. Whether these amounts to initiation of conciliation proceeding or not, that your lordship has to accept. From the above written statement and evidence of both sides, let me decide whether the workmen are entitled to wages for the period of strike and for the period of lockouts. The union's first contention is that during the conciliation proceeding, the management declared lockout, and as such, the lockout was illegal. But they failed to show any document that during the relevant period, any conciliation proceeding was pending before the conciliation officer. From the letter dated 27/11/2007, Exhibit 9, it reveals that Exhibit 29, it revealed that the labor officer fixed 30/11/2007 for cordial discussion between the management and the union. This letter cannot be termed of initiation of a conciliation proceeding. So labor officer invited both the parties to come with him for a mutual discussion. Whether this issuance of this letter amounts to initiation of conciliation proceeding or not. This letter cannot be termed as the initiation of conciliation proceeding in view of the provision of the Industrial Dispute Act 1947, read with Assam Industrial Dispute Rules 1958. Accordingly, the contention of the union cannot be accepted. There was no conciliation proceeding on the date of declaration of lockout by the management, that is on 29/11/2007. Although the witness of the union, Sri Govind Kalita, in his evidence on affidavit stated that workmen never resorted illegal strike. Paragraph 7 of the written statement, the union admitted that from 27/11/2007, they took the path of educational program. It is our stand, yes, we have resorted some educational program. Whether this educational program amounts to strike or not, that is to be examined. From Exhibit 27, 28, and 29, 30, and 32, it is apparent that by means of educational program, the worker resorted to illegal. Now, that is the basic error in construction. Resorting a strike and resorting an educational program, whether they stands on the same footing or not. Strike, that has been specifically defined under section 22Q. That amounts to cessation of work. It is apparent that by means of educational program, the workers resorted illegal strike, in spite of the reputed requested by the labor officer and the management to desist from it. Our protest was against the appointment of the contract laborer, engagement of the contract laborer in the places where the regular workers are working. So for that purpose, we resorted our educational program. Whether that resorting of educational program amounts to a strike or not. According to the learned presiding officer, this amounts to a strike. Educational program, the worker resorted illegal strike in spite of reported request by the labor officer and the management to desist from it. Mr. S.N. Sharma, senior advocate of the management, submitted that due to the continuance of illegal strike by the workmen and due to get apprehension about the safety and security of the management staff, as well as the plan and the decisions of declaration of the lockout, the management had no other option but to take a decision decision of declaration of lockout. Accordingly, the management declared lockout with effect from 29/11/2007. The learned senior advocate submitted that as the workers themselves resorted illegal strike, according to the educational program was considered as an illegal strike. They cannot claim wages for the period of strike since 27/11/2017 to 29/11/2017. Because from 29/11/2007, lockout was resorted. There was no work. As a lockout was declared in consequence of the illegal strike, the lockout was legal. As the lockout was declared in consequence of an illegal strike, lockout was legal. Therefore, the question of wages for the period does not arise. In support of his submission, the learned advocate cited the case of management of such and such, reported in AIR 1968-93. I have gone through this judgment. I don't think that this judgment has any relevance, wherein it has been described the lockout as the antithesis of a strike and legitimate weapon available to an employer to persuade by a coercive process the employees to see that the employer's perspective to accept demand by refusing to furnish work, the employees accept on the terms of the employer. I will refer the judgment subsequently. I found force on the submission of the learned senior advocate. In the present case, the workmen resorted the lightning strike on 27/11/2007 and continued with that even after repeated request of the management and labor officer to desist from it. They hurled stone bricks towards the clean area, abused the management staff, using slang or unparliamentary words, and threatened the management staff to burn a leaf inside the factory. Under such circumstances, for safety and the security of the management staff, as well as the plant and the machineries of the factory, the management compelled to declare lockout. As per Section 24(3) of the Industrial Dispute Act, lockout declared in consequence of an illegal strike shall not be deemed to an illegal. Therefore, I am of the opinion that the lockout in the present case was legal, since the strike is illegal. Strike is illegal and the lockout is legal. The workmen are not entitled to wage for the period of strike and lockout. Another aspect is that by Exhibit 42, that is the settlement below, that has been established. A conciliatory settlement dated 23/7/2008, the parties agreed specifically that for the period of strike lockout, the principles of no work, no pay would apply. Section 42, it should be Exhibit 42. Exhibit 42 is a sacrosanct document so far as the industrial dispute is concerned. The learned presiding officer failed to appreciate the provision as contained in clause 4. That totally is ignored. It's very much clear that another aspect is that by Exhibit 42, realized the conciliatory settlement dated 23/7/2008. The parties agreed specifically that for the period of strike of the lockout, the principles of no work, no pay would apply. Section 42, that is Exhibit 42, is a sacrosanct document so far as the industrial dispute is concerned. Had it been considered by the learned presiding officer, probably the award would have been deferred. Because he was impressed by this.
Mr.
conciliatory-
Dasgupta, here, I would have put the question later on, but.
Yes,
it
yes,
might
most
escape.
welcome, yeah.
See, section 18 is there.
Yeah.
It lays down a finality on certain conditions wherever there is a settlement. But here, even if we go to the actual meaning of clause 4
Ah.
of the memorandum, that clause 4 has two parts. No work for no pay for the period, but at the same time, the adjudicating authority would adjudicate on the issue of the justification of a lockout as well as
Right,
this
right.
strike. First part you can ignore. Second part, if the second part would have gone in your favor, then the first part would have had some meaning. Now the second part, since it's been decided in against you,
Yes, well, lockout.
then we may not even require to go to the application of section 18. Even that is not even the consideration.
Hmm.
That 18 applies, so you are barred.
Hmm.
You are you are bound by the settlement.
Yes,
Labor
yes,
code has
yes.
gone into the respect of the legality, illegality of the strike as well as lockout. So the other aspect of 18, which we initially thought may not be very relevant.
Yes, yes, I am fully appreciating, no, Vijay, because if they can make out a case that lockout was totally justified.
No, no, if the labor code was fully only focusing on the aspect of without going into the legality or justification of the lockout and strike and simply saying that there is a clause, no work, no pay, so no pay. That is not the finding.
Yeah,
Finding is initially that the lockout has been held to be legal because the strike has been held to be illegal.
yes,
And therefore, it automatically comes that you may not be entitled to the.
if the strike is illegal, then the management has a right to resolve.
Now,
Well,
I think your sphere
For the
of,
timing, we
sphere
can
of
pick it up.
argument would be, I think, have to be focused on whether the educational programs which you resorted to
Amounts to strike.
comes under the definition of strike.
Strike.
Okay.
Yes,
And if it is strike, whether you have overcome the obstructions, the embargo laid down in 22 and 23
okay, 22,
and 23 of the ID Act, because you can have a strike, but you need to give notice what kind of duties are you imparting. It's a duties is of essential nature. If it is not, what is the period of period of notice? 22 and 23.
yeah. My case before your lordship is that we have not resorted any strike.
Okay.
So as we have not resorted any strike, so the question of compliance of section 23 does not.
Have you exhibited any document, any memorandum or any resolution taken by the union? What is the educational programs you are going to
Yes.
resort to? Where is it where are those exhibits?
Yes.
Exhibits? Because the onus will lie upon you unless you discharge your burden, then only the onus will shift upon the management. Initial burden is upon you. If you say that it's not strike, it is only an educational program, maybe shouting of slogans or something like that.
But that will come from their evidence itself. Milord.
No, did you must have taken some resolution in a meeting of your
Yes, sir.
union.
Yes.
Resolutions have been exhibited or not? See, these kind of matters, you can prove either by oral evidence or by documentary evidence.
Okay.
Oral evidence, we have already we have a fair idea what you had stated. But there is only one witness, Govinda Kolita.
Hmm.
One witness. But we do not know what are the documents you had exhibited.
Ma'am, all the documents have been exhibited by the management.
No, management can exhibit the notices which the managements were in possession. What about the resolution if you have taken at all regarding what nature of activities, agitational activities you would resort to? Suppose we assume that you had a genuine cause to be agitated.
Yes.
you resort to an agitation program. What was the resolution? What kind of agitational programs did you undertake? There has to be some resolution.
Yes, yes, yes.
Those are not exhibited. Those were not exhibited.
Yes, that has been exhibited.
Which one? Exhibit what?
Lord, that is the annexer A to our evidence.
Yes. What is that?
That apart from that, we have some other regulation. I will state it out. May I read this
Yes,
regulation?
please. Please.
Executive body meeting of the union
Yes.
held on 23/11/2007
Hmm.
adopted the following resolution unanimously.
Hmm.
Resolution number 1.
Hmm.
It has been reported that the management has been trying to engage contract laborer
Correct.
other than the clean area. The union hereby expressed its strong protest over the same and demands not to engage contract labor in any place other than the clean area. The union therefore resolved to resist any such step in future. It has also been resolved that if any contract laborer engaged in any other place except the clean area, all the workers shall stop their workers in forthwith.
Stop there.
Work forthwith. If it is other work. Resolution 2. The union hereby expressed, whether it was considered in action or not, that is to be examined. That was a regulation that yes, we have a settlement. But by that settlement, management agreed to engage some contract labor in clean sector. So 50 contract labor license was granted to engage contract labor. So we have agreed with that. So our contention was that you should not engage any other contract labor in any other sector other than clean. If you engage any contract labor, then we shall take some actions. Stop. Resolution number 2.
Yes.
The union hereby expressed its strong protest over the outstanding policy of the management. The union therefore resolved to resist any attempt of outsourcing other than the existing place to Assam place. Yes, Assam Carbon Ancillary and Power Carbon. The union therefore demands not to go for outsourcing any other areas except existing place mentioned above. That is our specific stand. Resolution 3. The union further decided to continue the ongoing educational program. Probably they are harping on that program. Educational program of slogan. That is very much specific. Slogan and protesting and further to wear black belt during the duty hours. From today, we shall protest and we shall wear the black belt from today as a mark of protest. So whether we can exert this right or not, we have a right to protest that you should not engage contract labor to any other section. And if you engage, then we shall resort to a strike. And if we resort in a strike, definitely we must abide by the condition as contemplated under the Industrial Dispute Act. But we had no occasion to resort strike. Regulation 4. The meeting reiterates its demand to regularize the services of all casual workers who were continuously working for a long period. So what is the harm of it? So what is the harm of resorting slogan. And what is the harm of wearing black badge? I don't find any reason, you know. Yes, we have taken a decision. If you take the decision, then we shall resort to strike. And if we resort to strike,
Was it,
definitely we shall.
was there actually an instance of stoppage of work?
Yes,
There was. Was there actually an instance of stoppage of
No.
work from your part?
no. That is their burden. We took a resolution that you should not resort to any, engage any contract labor other than this sector. If you resort this sector.
No, no, that we have followed, that it is a condition,
but-
it was a conditional resolution. That if you go ahead with having contract laborers in other
Other
sections
section.
other than the clean area, then we'll resort to strike.
Yes.
You say that occasion never happened,
Arisen.
never had happened.
Happened.
And so it is upon them to show that you had ceased to work, and therefore they were justified in declaring
Declaring lockout.
lockout.
That
It
is
is
their
upon
burden.
them. But you have said that you have never stopped the
Yeah.
work.
We'll stop the work. But we have made a protest.
That is okay.
Yes,
That is
because
okay. That we
we
have,
shall wear
that
plain.
we have seen.
That is, we came with this candid disclosure, but, and we have intimated them.
One ancillary question.
Yes, ma'am.
Is there any instance of any retrenchment of your, any of the member of the union?
No,
No, there was no
they
retrenchment.
didn't. That was their stand, that they will engage contract labor, but while engaging their contract labor, they will not retain any regular employee.
No, that is exactly the question we are trying to ask. Because see, there is a report which was agreed to by you that you, in fact, it was your demand as per the award that you have an assessment on the capability of the machineries.
Machinery.
A study was done in a joint kind of an assessment, and study says that the machines were underutilized.
Hmm.
Underutilized. And the stand of the management is that the efforts which you should have given was not forthcoming, so that they had resorted to
Engaging contract labor.
of engaging extra hand by way of contract labor, and
Contract.
therefore they have got themselves registered under the 1970 Act. So now you have responded that there was no instance of any retrenchment.
Yes.
You are not removed and replaced by somebody. So what was your difficulty in extra hand coming in to increase the capacity?
Not so far, the engagement of contract labor in the regular employment is an unfair labor practice. Because
No,
by
see,
engaging, by
see,
engaging
Mr.
contract labor,
Dasgupta, you may have a point, valid point, unfair labor practice, but unfair labor practice unfortunately is not one of the references, terms of reference, so we will not
no,
go into-
anyway, let me consider that demand is not justified.
Yes,
That does not mean that we have resorted to illegal strike. For the timing,
yes.
as
Yes.
your lordship posed this question,
Yes.
let me consider, yes, that
Oh,
demand
yes.
that demand is not justified. Though I have some reservation, but I am not going to the controversy.
Your main contention now is that
Hmm.
they have to prove that there was a cessation of work by you, whereby they were justified to declare a lockout.
Lockout.
If they cannot prove that there was a strike from you, then their lockout also goes, and therefore you may be entitled to the amount.
So we are not going, as your lordship question, raised this question, let me consider, yes, that we may not be, it is not that always that our all demands will be justified. We may be some unjustified demands.
Okay. We have more or less have an idea of your thing. You said that this Kaibete is not applicable. 1960 AR is not applicable.
No, the 1960 AIR says that if there is an illegal strike, then management has a right
That is
to.
the principle.
That is the principle.
But that is not, the situation is not applicable.
Not available. If
Okay.
they have to stay,
Any decisions you're relying upon?
right now, I have got some decisions, day after tomorrow. If
These
we
are
are-
old matters. We are not giving day after tomorrow. You get the decision till we hear Mr. Tiwari. And any more thing we have, any depositions you'd like to rely upon specifically?
So this is my contention. Let me argue his case.
Okay.
If your lordship
Okay,
finds
fair.
any things to be asking to, I will,
Oh,
I shall try to clarify this to her.
Okay.
You know, though there are some other exhibits, I will not trouble your
Okay,
lordship.
okay, only relevant. Fair.
If relevant that I will, so when your lordship will see? They are for tomorrow.
No, 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 we are having it continuing.
No, no, let him argue.
That's not. If you want to say anything more, you can conclude it. Otherwise.
No, let him argue.
Okay, yeah.
Yes, as your lordship has rightly pointed out. And then
Okay.
so far the other things are concerned whether,
Let us see how Mr. Tiwari reacts.
yes, how.
The first query that is following from my lordship is whether the strike is legal or it is illegal. So far as the illegality of the strike is concerned, my lord, we have produced adequate evidence before the London Labour Court. Straight away, I will take my lord to the evidence. What evidence were there? My lord will see, just a minute, my lord, I'll, just for the convenience of a lordship,
Yeah,
I
yes.
will have a very small resume, which I will take, I'm placing.
Fine.
The strike, my lord, began on 27/11/2007. That is the date. Prior to beginning of the strike on 27/11/2007, when I use the word strike, by that I mean cessation of work. And my lord, that is in conformity with their own resolution. They had threatened that they will stop work completely if the demands are not met. So there was a cessation of work.
No, no,
I'll
Mr.
I'll come
Tiwari,
to that.
he says that it was a conditional resolution.
Maybe.
If you engage contract laborers in space areas other than the clean area, we would resort to strike. And Mr. Dasgupta on repeated asking from the court has said that that situation did not arise.
We-
But they had resorted to other additional agitational activities like shouting of slogans, wearing of black badge, and for which you had declared the lockout. That is his case.
So, my lord, our evidence is that there was a complete cessation of work on 27/11/2007, which was wholly uncalled for. And that cessation of work, which we call strike legally, on 27/11/2007, was in violation of the mandate of section 23 of the ID Act. Priar to 27/11/2007, there was a course of agitation. The course of agitation, in fact, started much earlier. If my lord would see my resume, it started much earlier. One way or the other, interruptions, disturbances, go slow, all kinds of tactics were being resorted to by the union. But finally, my lord, it all culminated on 27/11/2007 when they stopped work. The very factor, my lord, of their completely stopping work would be evident from the exhibits which we had shown to the London Labour Court. I'll come to the exhibits straight away. The relevant exhibits would be, my lord, 27, 28, 29, 30, and the evidence of management witness 1 and 2 both. First of all, the exhibit, 27, 28, 29, and 30.
See, your 27 is you are the author of 27.
Yes, my lord.
So that.
Very well.
That,
Then 20.
then 28 may be relevant because that is
Yes.
a letter by the authority
Yes, yes.
which had asked them to call off the strike.
We also wrote to the authority, that is the Assistant Labour Commissioner.
Yes.
And the Assistant Labour Commissioner reacted on our letter, and then the Labour Officer, Exhibit 29. Because there is no response from their side of all this. The Labour Officer, Exhibit 29, on 27/11/2007 itself,
No,
writes to the General Secretary.
Mr. Tiwari,
Hello.
the proximity of the letters is also very important. The
Well,
dates and proximity. You wrote on 27/11.
Yes.
It is on the basis of your letter that the Labour Commissioner had put a notice to them that don't go for the strike. We are not doubting your thing. It may be correct, truthful, but this alone may not be enough.
Firstly, my lord, I'll put it this way. Such a thing can happen. Number two, it was never doubted before the labor court. There is no contra evidence to this also. So, my lord,
Yeah,
I'm placing the evidence.
This would be a very valid issue, valid point.
There is no
We
contra
will have to
evidence.
see the conduct of the parties before the first court of facts.
Yes.
Whether there was any such a stand that there was never a call for a strike and it never happened.
Yes. That is the point I'm trying to make.
Okay.
So, my lord, Exhibit 29, the letter goes to the General Secretary.
Hmm.
Now, in response to Exhibit 29, what is the conduct of the General Secretary?
Hmm.
What did he do? Because thereafter, Exhibit 30.
That is your letter.
Yes, again, to the President Assam Carbon Workers Employees Union. Now, my lord, I asked myself, apparently, my lord, this evidence we produced, what else more we could do? One could very well say, well, apart from writing notice to the competent authorities, calling upon them to intervene in the matter, and this is the situation,
There may not be a documented evidence. You're correct.
there can't be anything else.
Hmm.
Now, my lord, the moment, my lord, we place these documents as an evidence before the London Labour Court, I asked myself, what ought to have been their response? Is it their case?
Do you have the chart of production on those dates?
The production of those dates?
No.
Regarding the production.
Or any statement by your witnesses?
A statement is there, MW1. The oral evidence before the Labour Court.
Let us see that.
MW1. The evidence of MW1, my lord, has been annexed.
See, two dates are very crucial,
Oh.
27 and 28. 29, the lockout was declared. 27th, you say that the strike was resorted to. 28, some notices were exchanged or rather issued upon them. And 29th, you had to resort to lockout.
Right?
So 27 and 28 dates are very crucial. Whether the factory actually functioned.
My lord, so far as the production, this chart, other things are concerned, I don't think it was reduced before the.
What is the
Labour Court.
oral evidence?
Oral evidence I'm coming to. My lord, also, merely because one particular evidence, which would have been a very, very strong evidence, was not placed. My lord, at least other evidence is there, and lordship will have to balance it as to against our evidence, what is their evidence when they say no, there was no strike. So that is it. And how did they react to our evidence before the Labour Court as to what they could elicit from the cross-examination of MW1 or the cross-examination of MW2? They could not elicit anything whatsoever. Not
Would-
even a
Would
suggestion.
also like to read the prelude of the settlement. Maybe we can find some materials in the settlement, tripartite settlement.
Mhm.
The prelude to it, what is the background narrative before we reach clause 4?
Straight away,
I think that will help.
then the resume, my lord, I'll just show
Okay.
the various dates. Because it all, the very trigger, my lord, is started from June, July 2007 period. The trigger was the machines are there, but somehow the workers were not performing properly. And the level of production was very, very low. So we said increase the production. The workers said nothing doing. The machines are old. So on this, there was a conflict. So July 2007, the union and the workmen adopted go-slow tactics, interfered in every decision of the management in functioning of the factory, refused to perform their duties properly. Consequently, the production of the factory was severely affected. Union also demanded that a study be conducted for arriving at capability of machines and productivity at the factory. So this is what led to the study by the NPC. August 2007, accordingly, National Productivity Council, a study was conducted at the factory in presence of the workmen. The NPC conducted a study and submitted its report, which is Exhibit 6. The report was there before the London Labour Court. As per the report, machines of the factory were underutilized, and as per the capacity of the machines, the production ought to have been double of the production made by the worker. Then 4/8/2007, a meeting was held in presence of the president of the union in the meeting, report on the study conducted by the NPC was furnished to the parties. 25/8/2007, management wrote a letter, Exhibit 7, requesting the President of the Union to advise the members to work towards the full implementation of the recommendation of the NPC. Union workers ignored the request of the management and refused to raise production as per NPC norms and continued to adopt go-slow tactics, resulting in lower production in the factory. Consequently, management issued various notices to the union requesting to stop go-slow tactics and raise productivity, but in vain. All those exhibits are there, 9, 10, 12, and 13, to show level of production is down, and the request is being made to the union to work towards the implementation of the NPC study report. 24/9/2007, in order to raise productivity and to save company from losses, the management decided to engage contractual laborers at the factory and got it registered under the contract labor such and such, which is Exhibit 14. This was exhibited 24/9/2007. We got ourselves registered. By Exhibit 14, registration certificate, the management was allowed to engage 50 contract laborers in the process of manufacturing, loading, unloading, and other work. These contract laborers were engaged firstly at clean area. They were engaged at the clean area. 25/9/2007, in connection with the engagement of contract laborers at the clean area, the general manager also held a discussion with the union, but the discussion did not yield any result. Opposing the decision of the management to engage contract laborers, the workmen started agitation and formed an unlawful assembly in front of the clean area and started hurling stones and bricks. In brief, Lord, I have given this resume. So these were the circumstances. From the very beginning, there were difficulties and the troubles. NPC study was done. Workers were told, look, this is what the report of the NPC is. It was with their consent that the report was prepared by the NPC after doing this study. So, but then they were not satisfied and difficulties were there in the establishment. Then on 13/10/2007, it was in these circumstances that the bilateral discussion was held between the management and the union. It is 13/10/2007, Exhibit 21. It is 13/10. Resulting in signing of the memorandum of settlement dated 13/10/2007. Exhibit 21. It was agreed that the workmen would implement all the recommendations contained in the study report of the NPC dated August 2007, and union and the workmen would cooperate in achieving the NPC norms. Now, my lord, this very settlement, which is Exhibit 21, is equally relevant for this very purpose, because when the settlement was made on 13/10/2007 between the union and the workmen, my lord knows the settlement is binding.
Union and the management,
Between the union and the management.
not the workers.
Sorry, between the union and the management, the settlement, my lord, is binding. It is sacrosanct also. Now, my lord, initially, the settlement under Section 19, subsection 2, Lord, you may see the idea. Section 19, subsection 2. Sorry. Section 19, subsection 2. I'll read subsection 1 also. A settlement shall come into operation on such date as is agreed upon by the parties to the dispute, and if no date is agreed upon, on the date on which the memorandum of the settlement is signed by the parties to the dispute. Subsection 2 is relevant. Such settlement shall be binding for such period as is agreed upon by the parties, and if no such period is agreed upon, for a period of 6 months. My lord, I take it for a moment, no specific date was there, assuming then, my lord, 6 months, it is binding. The settlement itself shows you will work towards the implementation of the NPC study report, meaning thereby you will neither take recourse to the agitational path, not to speak of cessation of work completely, which can be called a strike. So apparently, my lord, whatever they did post 13/10/2007.
We'd like to have a detailed look at 21 also.
Yes, Exhibit 21
And
is
in
stated by.
light of the arguments you are making,
Yes,
bringing in 21 under the ambit of 18 and 19.
yes.
So if you can show that 21 also restrains them to take up
Yes.
any educational programs
Yes, sir.
who are the issue of increase or the production capacity, then that may be a relevant factor.
Yes.
Okay.
So, my lord, exhibit 21,
Yes.
it is 15, not 13, I think, that's the mistake, sorry. The meeting was on 13/10 and
2007.
the discussion was on 15, yes, 2007.
It's
And fine.
created 100. Internal speak 100.
Mine is not paginated, my lord, but exhibit 21 from your lordship's record. The date of the memorandum of understanding and settlement signed by all the parties is 15 October 2007. 15, not 13,
15 October.
15th October. I correct myself. The meeting was held on 30. The proceedings were there before conciliation officer, government of Assam, on 30th October. They were representatives of the management. They were representatives of the union, general secretary, assistant general secretary, treasurer, many other members.
Okay.
The second page of the exhibit 21.
Hmm.
My lord will find. Clause 1. I read clause 1.
Exhibit 21.
Yes, clause 1.
Just a minute.
Terms of understanding,
Just
clause 1. It was
21. Terms of understanding.
yes.
Yes.
It was agreed between the parties that the workmen would implement all the recommendations contained in the study report of the NPC.
Yes.
The items contained in annexure A and B would be implemented as per terms covered such and such. The workmen would also implement and follow the categorization of items contained in annexure such and such. The new addition to the annexure such and such will be treated in the same spirit accordingly.
Clause 1.
Yes.
Categorization of item.
My lord, there is another aspect, but then for that, there is a separate litigation before this honorable court. Those cases also may come up. Lordship may see clause 7.
Yes.
For this, a separate petition is pending.
Hmm.
Clause 7.
Hmm.
In consideration of the above, the management, however, agreed as a one-time goodwill gesture to the following without setting any precedent: payment of bonus for the period July 2006, July 2007 as paid last year. Management would make all efforts possible to disburse the bonus before Durga Puja. Then that was that was different. That was different. Another increment was promised and all that. For the 2 installments were paid. That's a separate case. I just mixed up the 2 things. So, my lord, sum and substance of the whole thing is union had agreed that they would work towards implementation of the recommendation of the NPC, and this was the core of the settlement. So it was
Where
expected.
are the recommendations of NPC?
The NPC recommendation is exhibit 6. Exhibit 6. Exhibit six work study. Report on work study at Assam Carbon Products, National Productivity Council, Hyderabad. The recommendations, my lord, will find
Sector C of your it. Work starts.
so that's the recommendation. So that's it. I just am putting it.
Okay. This exhibit one, which is a notice of 37/2007, 37/2007.
Yes.
Is this is it translated in anywhere? Just have a look at this record. We'll just take a break. 8 rupees লাগিব না? অলপ ভালকে লৈ যাওক। বহুত ৰং আছে। এইটো yellow.
So, and the portion which was in ASME's, my esteemed colleague helped me to understand that. Now, my lord, what I found is, so far as exhibit 1 is concerned, which is dated 30th of July 2007,
Exhibit
exhibit 1,
30th, not July, 30th of July.
30th of July
Right.
2007.
Right.
That is the letter of the union complaining against the management that management is unreasonably expecting it to increase productivity. Some and substance of the complaint is that. To that, management replied by exhibit 2 and exhibit 3. Both are relevant, and management in exhibit 2, not to find that. It's these are very exhibit 2. Exhibit 2 by exhibit 2, which is dated 31st of July, the very next day.
Yes.
So management is very prompt in giving replies. Management says the heading is recruitment of trainee junior engineer in management cadre.
Yes.
We refer to your letter dated 30th July 2007 on the above subject. We would once again like to clarify that the management has been making every effort to resolve the matter. Unfortunately, the union's non-participation in bilateral discussions has led to the matter not being resolved. In this regard, our letter dated 28th July 2007 refers. It appears that the union has been avoiding a solution to the problem by resorting to one pretext after the other for not participating in a process of bilateral discussions. We find that you have referred to inclusion of consulting lawyer, a stroke consultant in the management team for discussion. It may be clarified that while it is the prerogative of the management to constitute its team for discussion, on this occasion, our team for discussion does not consist of a consulting lawyer or consultant as referred. Our team consists of such and such. Details given. Then in Exhibit 3, the management tells the president of the union regarding the productivity studies. It is dated 30th June. We refer to the union's suggestion for conducting studies for arriving at machine capabilities and productivity at ACPL. We are glad to inform you that, as desired by the management, has tied up with NPC for conducting such a study. So, my lord, simmering discontent was always there. That is 30th of July 2007. The core being expectation by management that they are not performing their duties properly and production has to be raised. Whereas the union's counter was the expectations of management are unreasonable. So be that as it may, my lord, the relevant date, namely 15th October 2007, which is the date of settlement, for which, my lord, my submission is it was binding under section 19 as well as under 18 also on both the sides. After that very particular settlement, some of the exhibits are very relevant, which I've checked right now. After 15th October 2007 settlement, there was 19th November 2007 letter of union, which is Exhibit 48, 19/11/2007. That is in the intervening period of settlement and the strike. In Exhibit 48, 19/11/2007 letter, the union gives a threat. It's a very categorical threat by the union, saying that initially we had agreed, this is what I was told by my esteemed colleague, initially we had agreed to raise the production, etc., in terms of the study of the NPC, but nothing doing now, unless and until the management meets our demand, we may go to any extent and management should be prepared for any consequences. It is a very open threat that anything is possible. So, my lord, my submission would be as to Exhibit 48, which is in vernacular. It's the very open threat. So, my lord, my submission is what happened on 27th November 2007 was something which was expected and it was very much alive in their mind and kicking. Then, my lord, after 19/11/2007, Exhibit 48 threat by the union, there are two more exhibits. 28th November 2007, Exhibit 30. It is our response. Yes, Assam Carbon reacts. 28th November 2007, Exhibit 30. What Assam Carbon says. 28th November 2007, Exhibit 30, my lord, I read. 30. 30. It is addressed to the President of the Union. Yes, sir, this has come to the knowledge of the management that on 27th November 2007, when the workers were working in the first shift, the union leaders at about 9:45 a.m. asked all the workers to stop the work. And accordingly, the workers had ceased work from 9:45 a.m. Thereafter, at the direction of the union, the workers of the first shift have given a false report that all the machines have broken down from 10 a.m. to 2 p.m. Similarly, the second shift workers have not resumed their work, though it was found by our engineers that all the machines are in perfect condition. These actions on the part of the union is an unfair labor practice and gross and serious misconduct on the part of the union leaders. for which the management will have to take appropriate action. It is also pertinent to mention here that a settlement dated 15/10/2007, the union has settled all the disputes with the management, and as such, the actions of the union is in violation of Section 23 of the Industrial Disputes Act. So practically, my lord, the management treated their action of 27th of November to be a kind of a strike because there was cessation of work. This is what the management says. It is immediately thereafter, after the strike. Because the strike was on 27/11 and Exhibit 30 is dated 28th November 2007. Immediately this was written. And this was referred to by the London Labour Court to say that there was a strike. And then, my lord, Exhibit 32 also.
What is 32?
Exhibit 32. Of course, this is our letter to Assistant Labour Commissioner,
Dated?
dated 29th November 2007. That is after the strike. Telling him that strike has really taken place. Talking of violence, lawlessness, indiscipline. Referring to the notice. Referring to his call for a meeting on 30/11/2007, albeit it was for a cordial discussion, but then that has been treated to be an initiation of conciliatory proceeding by my esteemed colleague over here. Our submission is going to be that is not an initiation of conciliatory proceeding. It could not have been. And for that, I will refer to the relevant provisions of
No,
Industrial Dispute
what
Act.
is your response to 29/11/2007 by the?
that about which the submission is made.
Yes, yes.
It is a initiation of a conciliatory proceeding.
Yes, yes. There, see
To
that.
that, my lord, to that my submission is.
No, let us see
22-4.
first see the contents of that letter. Reply to 32.
Okay. Oh, reply of. So, and all total exhibits are, my lord, 27, 28, 29, 30, and 32. These 5 exhibits refer to the factum of strike. And these exhibits were relied on by the London Labour Court. So far as the letter of the Labour Court is concerned, asking for cordial discussion on 30/11/2007, that is Exhibit 29. On 27/11 itself, the day of the strike. Because there were, day of the strike, there were very, very fast actions from both the sides. You know, ordinarily it happened. Therein lies the difference between the PSU and a company run by a private body. The basic difference is PSU, it is always a laid back attitude. But so far as the private bodies are concerned, my lord, even the little bit of loss, they react. So, my lord, the speed of this communication is nothing very, very unreasonable. It is possible. And ordinarily, my lord, we understand
No, no.
our
We are not on the reaction time of the management. We are on the issue of a letter being issued by the labor officer on the same date.
Yeah.
Labor officer is not a private
true.
body.
And my lord, we should
Labor
rather
officer
be rewarded.
As you have used the
I
expression
was about to say.
laid back.
Late.
He's also
Here, my lord,
in the category of laid back,
my lord,
maybe much
that, my
more
lord,
laid back.
I was a rider. And I was about to talk of that only, the reaction of labor officer. In our nation's ecosystem, we know very well, for all practical purposes, management maintains a very good relation with these bodies. Always. When they, at the drop of the hat, when there is a trouble, they always manage very, very quick reaction from the other side, from the government. And that is why, my lord, the emphasis upon the private sector. In Arunachal, my lord, it is NHPC only which has sung hundreds of crores. All the private parties ran away from the state. They lost some money, they ran away, they packed their bag. So, my lord, that is why it is not unreasonable. It happens. The labor officer, if it is PSU, he would not react. He will keep quiet. If it's a private company run by a private party, they will be able to write a letter. And we understand the reasons behind that. The
Okay,
ecosystem is
Mr. Dasgupta was emphasizing upon the pendency of a conciliation
Yes,
process.
I'll come to that.
Which is that letter by which
my lord,
he is trying to?
Exhibit 29, letter of labor officer dated 27/11/2007. In my list of dates also timeline, my lord will find that.
Yes, what
Date I have referred.
yes,
27/11/2007, exhibit 29, letter of labor officer.
yes, what is the content?
I'm reading. Then I'll make my submission. 2-4. Dear sir, from the contents of enclosed complaint, letter dated 26/11/2007, that is just a day before the strike, submitted to this end against your union by the management, regards the subject mentioned above. It has come to know that your union is not complying with the direction of this office under reference to desist from any form of educational programs on already settled issues. Rather, it is alleged that your union has announced fresh educational programs on the same issue with immediate effect, defying the official direction of this end, which is bad in the eye of law, apart from the scope of a smooth industrial correlation between the parties. However, a date of joint discussion has been fixed at this office so as to enable to discuss the matter cordially in details on 30/11/2007 at 1 p.m. Positive. So it's a request, come for a cordial discussion. Now, my lord, as to why treated to be initiation of a conciliation proceeding, my submissions are going to be the following. Namely,
Yes,
the relevant provisions are the provisions, section 20, subsection 1, which deals with commencement of conciliation proceeding. Section 20, subsection 1. Whether my lord has got it? Yes. Section 20, subsection 1, commencement and conclusion of proceeding. A conciliation proceeding shall be deemed to have commenced on a date on which a notice of strike or lockout under section 22 is received by the conciliation officer, or on the date of the order referring the dispute to the board, as the case may be. So, my lord, section 22 is not attracted over here. We are dealing with section 23. So, my lord, I am emphasizing upon the word on the date of the order referring the dispute to a board. The board is the conciliation board. I will show that. The next is definition clause 2E, which defines conciliation proceeding. Definition clause. I come to 2E. Conciliation proceeding. Definition clause.
yes,
Conciliation proceeding means any proceeding held by a conciliation officer or board under this act. But, my lord, this definition gets qualified by section 23A. This also may kindly be seen. 23A is very important. When there is a prohibition on lockout. 23A.
just a minute. (23A).
Yes, my lord. I begin with the recital.
Yes,
General prohibition of strike and lockout. No workman who is employed in any industrial establishment shall go on strike in breach of contract, and no employer of any such workman shall declare a lockout. Referring to me, I could not have declared a lockout, A, during the pendency of conciliation proceedings before a board. This is vital, quote unquote. Before a board. And 7 days after the conclusion of such proceeding. So, my lord, my submission is going to be that the lockout was legal because it was in conformity with section 24, subsection 1. That is the first part, subclause 1. Or section 23 small a, because no conciliation proceeding was pending before a board within the meaning of section 23A. The labor officer is not a board. And then secondly, my lord, the board is constituted by an appropriate government by notification in the official gazette, section 5 of the IDA. Section 5 mandates that the appropriate government by notification in the official gazette constitutes a board of conciliation for promoting the settlement. That's the mandate of section 5. Board of Conciliation. The appropriate government may, as occasion arises by notification in the official gazette, constitute a board of conciliation for promoting the settlement of an industrial dispute. So, my lord, 23A, read with section 5, read with section 20, subsection 1, and definition clause 2E. The mandate of the law is the board of conciliation, the conciliatory board, and it is to be referred to it. The dispute has to be pending before it. The labor officer, my lord, therefore my submission is that the letter of labor officer dated 27th November 2007, exhibit 29, to the union fixing 30/11/2007 for cordial discussion was not an initiation of conciliation proceeding within the meaning of section 223A. That's the submission. Now, my lord, so far as the legality of this strike is concerned,
Just give us a minute.
Huh?
Give us a minute. I'll
oh,
just-
sure, of course.
Yeah, but you must have noticed that the use of the expression board is with an intention,
Yes.
because 22D does not use board. 22, section 22, which deals with a similar prohibition so far as public utility service is concerned. Is this see the language?
That interpretation can be given.
No, the expression is during pendency of a conciliation before a conciliation officer.
Yes.
But in case of an ordinary industry, it is before a board.
And 23A, my lord, specifically uses the expression before a board.
Before a board.
The
And
labor officer is not a board.
22 is a very liberal kind of an expression
Yes.
because it deals with public utility services.
Yes.
So even before a labor officer, it may be construed to be
Because
a
of
conciliation
It being
procedure.
a public utility.
Public, here, the construction is more strict,
Yes.
stringent. It has to be a board.
That is the, my lord. Right, my lord has correctly interpreted that. That's the intention.
Okay, please.
So, my lord, my first submission, namely the settlement dated 15/10/2007, 15th October 2007, was binding on the union as per the mandate of section 19 subsection 2 and section 18 subsection 3. It was binding. There can't be two opinions about that. Number one. Number two, the subsequent events clearly indicate that the union acted in breach of the settlement. Even taking recourse to an agitational path was an act in breach of the settlement, which was binding on the union. And this is buttressed by the fact of union itself writing a letter in the intervening period of 19/11/2007. The letter, which is in vernacular, dated 19/11/2007, Exhibit 48, wherein the union gives an open-ended threat to the management of dire consequences and be prepared for any situation. Any situation, my lord, at the most it could be total and complete mayhem, including a strike. Nothing else. So, my lord, they acted as per their threat. And not only that,
Yes.
after Exhibit 48, that is after the threatening letter of 19/11/2007, there are communications by the management dated 21/11/2007
Yes.
and 23/11/2007, Exhibit 24 and 25, to the Assistant Labour Commissioner, requesting him to direct the union to comply with the settlement. So, my lord, our intention is bona fide. We are trying to persuade the union, which is practically is acting like a warmongering force. Then, my lord, a letter by labor officer prior to strike, which is dated 23/11/2007, Exhibit 26, is equally vital. Lordship has seen that. The labor officer urged upon them to comply with the settlement, which is binding on them under Section 18. Thereafter, the strike, 27/11/2007, not surprisingly going by the conduct in the past. And without the factum of strike, my submission would be, is evident from the following exhibits, namely 27, 28, 29, 30. These exhibits make it very clear, including 32, where much can be read about the past. And my lord, the Learned Labour Court relied upon these exhibits. And my lord, certainly, my lord, the view of labor officer, the view of Learned Labour Court, which is formed on the basis of this examination of these exhibits and the events of the past, some of the exhibits pertaining to the past, my lord, would necessarily lead to the conclusion that yes, there is indeed was a strike. And my lord, the finding of the Learned Labour Court that there was a strike cannot be called perverse, because my lord, ultimately we are in certiorari jurisdiction before the Honorable Court. Either it is perverse, if there is some evidence by which any reasonable person would come to conclusion that yes, there was a strike, my lord, that opinion would prevail. That's my submission. And my lord, one more thing has been shown to me, namely, that is, which Lordship has already seen it, Exhibit 49 of the Union, letter of the Union, Exhibit 49, which is the resolution dated 24/11/2007, which is again before the strike. The strike was on 27. So this resolution is dated 24/11/2007. In resolution number 1, the Union talks about
24?
24/11/2007, 3 days prior to strike.
Exhibit?
49. In resolution number 1, they say about stopping the work forthwith, which is an indication of strike, clear cut. Resolution number 1. In resolution number 3, they talk about of continuing, because that was a continuous process, continuing with the agitational program of slogan shouting, postering, and further wear black badge during duty hours from such and such as a mark of protest. So the two things, what we are doing, we'll continue to do, and finally be ready. We may even stop the work. So what happened on 27 was not surprising, considering their posturing from the very beginning, after the settlement, series of exhibits. So therefore, my lord, the first submission, the strike dated 27/11/2007 was in breach of settlement dated 15/10/2007, and therefore, which was binding on the Union as per the mandate of Section 19, subsection 2 and Section 18, subsection 3. So number 1, there was a strike, and number 2, because of the breach of settlement, settlement exhibit is 21.
1510 is 21.
Yes, 21. So being in breach of settlement, and therefore, which was binding on the Union in terms of Section 18, subsection 3 and Section 19, subsection 2, it is illegal, the strike illegal. So the illegality flows from Section 19, subsection 2 and 18, subsection 3. Because if you act contra to what is binding on you, you act illegal. And there is a strike, there is a fact, which is established by submission on preponderance of probability. Because ultimately, my lord, that will be the test. There is some evidence on that. Of course, my lord, the best possible evidence could have been the production chart, etc., etc. Then not being there, we have the other evidence. And the entire series of events by way of exhibits. And of course, the oral evidence of MW1 and MW2, both have spoken about the strike. So, my lord, illegality of the strike.
You mean to, your contention would be that since the degree of proof is preponderance of probabilities, the materials which are available before the labor court were sufficient to come to a conclusion of the factum of strike. And that being a finding of fact, this court will be very loath to interfere with. Unless they can establish that it is based on no evidence or perverse.
Because we are in certiorari jurisdiction, my lord. That's my twofold submission. So, my lord, lockout is a consequence of strike. Lockout being consequence of strike, apparently, my lord, is not illegal. Because lockout does not violate Section 24(3) of the Industrial Dispute Act.
Yes.
Section 24, subsection 3 may kindly be seen.
Yes. Yes.
So, my lord, Section 24, subsection 3.
If a strike is illegal, the lockout can be resolved. That is the point.
A lockout declared in consequence of an illegal strike, or a strike declared in consequence of an illegal, yes, of course. That is what it is, the mandate of Section 24, subsection 3. And moreover, the lockout did not violate Section 24, subsection 1. Apparently, Union is unable to show any violation of Section 24, subsection 1. A lockout is illegal if it is in contravention of Section 23. because there is no conciliatory proceeding pending. That's my submission. 23 in the present case could only be attracted if there was a conciliatory proceeding pending. It was not pending. So lockout fulfills the test of section 24 subsection 1. Sorry, 2. 3. Section 24 subsection 3 of the Act.
See, 3 is a two-way traffic.
Yes. So
Two-way traffic. If
if I
this-
can establish a strike is illegal,
then lockout becomes legal. And if the lockout is illegal, then the consequential strike. Now the moot question would be, what is the consequential event? In this case, till now, we have not come across a situation either by you, of course, will not plead. Even Mr. Dasgupta has not pleaded that
Consequence will
they had
be
resorted to
evacuated.
strike after the lockout was declared. That
they
is
may
not
get the
the
back
case.
wages. If the lockout is illegal at the most importance. But in any case, it is not illegal. And more so, my lord, no conciliation proceeding pending under section 23A. Lockout could have been illegal had there been a conciliatory proceeding pending under 23A. None was there.
No,
So,
even to go to the aspect of legality or illegality of the act, it is the legality of the illegality of the act which comes prior in point of time. If it's a lockout, it has to be followed by a strike, or if it's a strike, it has to be followed by a lockout. The consequential action is saved by 24(3).
Yes.
So it has to be pleaded that your lockout was the first action which was followed by a strike. That is not his
That's what
pleaded
the
case.
case is preceded the strike. Obviously. So, my lord, that's it. And my lord, the other aspect of the case is we come to exhibit 42.
Hmm.
The settlement which says no work, no pay for the period of strike. That's another submission made. For that, the argument is the union, this was a settlement made with a different union, not with us. Now, my lord, that union was a recognized union. Number two, the union did not come into existence during the period of lockout. It came into existence much before the period of lockout. There is an evidence. Sorry.
How long will you take?
Not much. I'm touching upon the legal
If you are
aspect.
completing within 5-10 minutes, we can continue now. Or if you can come at 2 o'clock.
The queries may fall from your lordship.
Okay.
So
We'll come at after
let it
lunch.
be. Because
We'll come after lunch.
Sure.
The 14 and kind of maybe close it, but yesterday it came up I.
Okay.
14 and
Only Mint logistics.
yes, mean logistics and my global speed.
Who is on the other side?
I'm there.
Okay.
14 is there. In 15 my SC exile will be there.
SCXI লিখে লবা না? আরে
D
তোমার
Gogoi.
নাম কি? D Gogoi.
Okay.
We'll continue at 2 o'clock. We'll complete the arguments today.
But let him complete that.
Happen to be a advocate of this bar as a fair your lordship. 2 weeks. I mean,
CD is there, Lord. CD will be,
We'll have it after 2.
2 weeks.
CD is required.
CD is here.
Okay.
CD
You
will be
retain this. Okay.
after
This Sri R. Muzumdar, Learned Counsel, has informed this court that Sri R. Dhar,
Arthur.
Learned Counsel appearing in this case is under bereavement and accordingly prays for an adjournment. Full stop. The learned additional PP has informed that the case diary has been obtained. Full stop. Para. List for consideration after 2 weeks.
Probably.
Waive your loss.
Yes.
Mentioning item number 8, by the way. This case I am appearing for the respondent. Our Mr. name of Mr. C.K. Roy was going, so there was a confusion.
FCI matter.
FCI,
You will be appearing.
I am appearing.
A matter of which year?
23 men,
Okay, it's for what? Admission?
admission. be taken up.
Why 2 weeks? I think pleadings have been exchanged.
Critics have been exchanged.
Maybe day after tomorrow, or maybe Monday next, or Tuesday next,
On 14, my
on Tuesday next.
Tuesday I'll be 14 is first.
Your
Okay.
Lordship, my senior counsel, Mr. Jain Sahiwala, will not be available.
Tell us the date of your
28.
20. 20.
12th. You are not there, Mr. Singh.
Yeah, I'm outside.
15th,
Your Lordship, my senior counsel,
then 18th.
Your Lordship, he will not be available on that date.
Which date is
On
coming?
19 or 20.
20, Your Lordship.
Okay, 2820. Item number
Item number 8.
on the request made on behalf of the parties list on the matter is adjourned and is to be listed on 23/2024. Full stop registry to reflect the name of Sri B.K. Singh as counsel for FCI.
Obliged.
Now, my lord, I have addressed your lordship on two principal issues, namely that the strike was illegal, and number two, the lockout was legal. While addressing my lord on these two issues, I also, my lord, discussed namely the binding nature of the settlement dated 15/10/2007, that the strike was contrary to the settlement dated 15/10/2007. And secondly, my lord, I also discussed that the lockout, while being legal, was also cannot be said to be taken place during the currency of any conciliation proceeding. So both the aspects I explained. Now, my lord, after this, the third important aspect on which, my lord, I will address my lord is the binding nature of the memo of settlement dated 23rd of July 2008, which is Exhibit 42. Now, my lord, my esteemed colleague has tried to overcome the very hurdle of the binding nature.
What is the date of the settlement?
23rd July 23/7/2008.
Exhibit
42. This very settlement spoke about no work, no pay during the period of strike and lockout. And the London Labour Court relied upon this very particular exhibit to take a view that even otherwise, there could not be any demand
Yes.
for back wages during this period. So, my lord, my esteemed colleague tried to overcome the very hurdle of the binding nature of this settlement, 23rd July 2008, by advancing an argument that this very settlement would not be treated to be binding because a new union came into being during the period of the lockout.
That perhaps will not.
No,
There's
I'm not
nothing.
arguing this.
I think this was the argument.
No, even if that is argued, I don't think that is sustainable. But
Yes,
here, Mr. Dasgupta will not argue that.
Very well. If that be the case, even
Because it
otherwise,
is binding on all,
union-
it is binding on all, the language is very clear.
Well,
Ah.
And, my lord, if any authority is needed on the subject, I can cite only one judgment.
Please do.
Straight away. On this very aspect, on this 1991, 1 SEC, page number 4, relevant para 8.
Name.
The party's name is Barauni Refinery Pragatishil Shramik Parishad versus Indian Oil Corporation. Judgment is authored by
Paragraph.
paragraph, my lord. The relevant paragraph is paragraph 8. It is from Placitum G, the relevant portion. It's a very big paragraph. It starts from page 10, but the relevant portion, my lord, begins from Placitum G at page 11.
Q1.
Just a minute, please.
It may be seen.
Paragraph 8.
Para 8, page 11, Placitum G,
Even the 1990.
in the last.
There is no placitum here.
My lord, here.
No, here in the
1991,
printed copy, there is no.
sorry,
plus.
1991, volume 1.
Printed copy
There's
does not
not
have.
a-
No, doesn't matter, doesn't matter.
This is
Give us the line number around.
1991, volume 1.
No, give the line number.
Line, my lord, after
Quoting
section 18
18(3).
subsection 3.
After
18
quoting-
subsection 3 was quoted.
Yes, it
So
may
after
be,
the quotation,
it may be seen.
it may be seen.
Okay.
This I read. It may be seen on a plain reading of subsection 1 and 3 of section 18 that settlements are divided into two categories, namely those arrived at outside the conciliation proceedings and those arrived at in course of conciliation proceeding. A settlement which belongs to the first category has limited application in that it merely binds the parties to the agreement, but the settlement belonging to the second category has extended application because this settlement, my lord, was the culmination of a conciliatory proceeding. The subsequent settlement
Yes.
regarding no work, no pay. But the settlement belonging to the second category has extended application since it is binding on all parties to the industrial dispute, to all others who were summoned to appear in the conciliation proceeding, and to all persons employed in the establishment or part of the establishment, as the case may be, to which the dispute related on date of dispute, and to all others who joined the establishment thereafter. Therefore, a settlement arrived at in the course of conciliation proceedings with a recognized majority union will be binding on all workmen of the establishment, even those who belong to the minority union which had objected to the same.
That is procedure.
To that, very well, then I need not.
Yeah, I need not.
So nice of my esteemed colleague.
Conciliatory settlement is binding to us.
Very well. So if this aspect is not being argued, my lord, I need not. I will just give the citations.
And
With
it is
other-
okay, one is okay. Baroni is okay.
So
No,
other,
no need of anything.
very well. That is the exhibit. That is settlement. That is settlement. My lord has seen it already.
42.
Yes. Exhibit 42. Yes, exhibit 42
Clause 4.
and clause 4.
Yes, we have seen
You've
that.
seen it
We have
already.
seen that.
That's all.
Okay. Yes.
Blood, to me, the case is very simple. Let me take all the burdens with me that there was a strike. Let me assume, though I have argued that we have not resorted to any strike.
For the sake of argument.
For the sake of argument, let me assume that we resorted to a strike. So it should not be, for the sake of argument, we are
Okay.
not considering it.
Hmm.
Right? For our better understanding. Now, when a strike may be declared as illegal, that is the question. If the strike is illegal, then the management accrues a right to resolve lockout. That is the sum and substance of this article. Now, it transpires from the material on record that workmen do not want that the contract labor should be introduced in their act. It is an admitted position. And they went to the extent that if you introduce contract labor, then we may resort to a strike. That is exhibit 1. And let me assume that we have resorted to a strike. Let us go ahead with that. Whether this strike would be an illegal strike or not. When a strike may be illegal. Strike may be illegal during the pendency of a conciliation process. My learned friend is candid enough to point it out that there was no conciliation proceeding because it is a case, if the conciliation proceeding is pending before the board, then and only then the strike may be illegal. Had it been a case of the public utility service, then the conciliation proceeding will be pending before the conciliation. That is section 22 and 23. My friend is fair enough to point it out that there was a no conciliation proceeding before the board. Now, their contention is that
Hmm.
it was a breach of settlement.
Yes.
That is their contention. So for the conciliation proceeding is concerned, that has gone away. And now their contention is that it is a breach of settlement. Now, so for the breach of settlement is concerned, they are harping on the settlement that is Exhibit 21. Am I wrong?
Exhibit 42, I think.
No, 42 is subsequent. Two settlements. Once by one settlement, that is Exhibit 42, the lockout was lifted.
I think Exhibit 21.
Yes, Exhibit
Exhibit
21.
21.
Now,
15/10/2007.
yes, 15/10/2007, that is it is page 160. Anyway, page may differ. Now, what are the
This
point-
clause 4 is of the earlier settlement, isn't it?
No, clause 4 is a subsequent settlement.
Okay.
There are
Now,
two settlements, my lord.
I will come to that.
Okay.
Probably your lordship is not in clear position, Lord.
We have seen now.
So let me, we shall start later on. Now, what is the content of the exhibit 21? Now, terms of this understanding, there are 11 clauses.
Yes.
Now, let us go through each and every clause.
Okay.
Now, first, it is agreed between the parties that the workmen would implement all the recommendation contained in the study report of
NPC.
National Productivity Council dated such and such August 2000, marked as Annexure C, except for the items contained such and such.
Okay.
The items contained in Annexure such and such would be implemented as per the terms covered by the clause such and such. This is not very relevant to introduction of a contract labor. Now, let us come to clause 2. It was agreed between the parties that the items contained in Annexure A and B would be implemented as per the minimum level shown in the Annexure A and B as referred to the shown in column marked as agreed. Let me read it slowly. It was further agreed that the union and the workmen would cooperate in achieving NPC norms by conducting a scientific production exercise like under the video camera, recording, etc., within the next working 10 days. The figures productivity as scientifically arrived at would be with floor figure achievement by the workman such and such. This has got no relevance to the introduction of the contract labor. Now, clause 3. Clause 1 and 2 would be implemented immediate effect. That is National Productivity Council.
NPC.
Clause 4. The union and the management agreed to work together for the growth of the company, and in case of any dispute, it shall be sorted out through bilateral.
Seen that.
All right. Discussion. Now, clause 5. It was agreed that consequent to the above joint petition containing the settlement as referred above would submitted before the labor officer come conciliation officer. The above terms of settlement would be submitted to the labor officer and the assistant labor commissioner at Guwahati for records of the government. This would be in reference to the grievances of the union raised by letter number such and such and various allegations raised by the man. So it does not have any bearing with the introduction of the contract labor. The management retained the right to implement the administrative decision and discipline within the purview of the industrial law. Definitely they should have this right. If anybody has committed some misconduct, they have the right. We have no objection whatsoever. That is clause 6. In consideration of the above, the management, however, agreed as one-time good That may have some relevance, but I don't think it has
Okay,
any
then
relevance.
bonus.
Bonus. So we have agreed with this, and they only after agreement of this agreement, the bonus was disbursed, and the production achieved its record. Highest production was achieved. After this, that is my pleaded case, and that is my pleaded argument. Evidence also. Let me skip it up. I will not refer these things. Now 8. Management also agreed, as stated in point number 7 following, reversal of the transfer order of Mr. Govinda Kalita, who was the General Secretary probably, and Kamal Chandra Dekar as special case. Wage cards on 14th August 2017, without setting any precedent, would be refunded. Withdrawal of charge sheet for not attending the relevant sheet from such and such date in respect of the individual assurance of good conduct in future. So-called notice to Mr. such and such would be withdrawn. That is with regard to a so-called notice issued to somebody else. That is withdrawn. Management also agreed to review the points raised by the union regarding the payment of annual increment by the letter dated such and such within the purview of the existing agreement. It has no relevance, my lord. The above would be full and final settlement. Full and settlement and all pending issues issued raised by the union are dead. These are the terms and conditions of the settlement. Payment of wages for the above shift workers. The management and union have agreed that the employees will avail the facility of check from the bank in case
That
of
is okay. We have seen that. That is not relevant.
that is not relevant. Now, what is their case? That we have resorted a strike. Anyway, let me consider that we have resorted to a strike. Whether this strike is illegal or not. Strike can be illegal only if it is in violation of the settlement, and it can be illegal only if it is in constitution violation of the
Statute.
Yes, strike may be unjustified. An illegal strike and unjustified strikes are on different footings. I am considering this. A lockout may be unjustified. Both. But every illegal strike or every illegal lockout are unjustified. Am I correct? Clear? You understand? Now, so in order to resort a strike, what are the formalities that is to be complied with? If it is a public utility service, the union owes some obligation to comply with. That is probably
22.
22,
Hmm.
probably.
It's 22.
May I read, Lord? No person employed in a public utility service shall go on a strike in breach of a
22 will not be applicable. It's not a public utility service. So 20, come to the next clause.
no employer carrying on public utility service shall lock out in his workmen without giving them a notice of lockout.
Next. General prohibition in 23.
23 years.
22 is with regard to both
Public utility service.
lockout as well as public utility as well as strike, so far as public utility service is
Service.
concerned. The next clause, next section 23 is with the general prohibition of strikes and lockouts.
Yes, sir.
Yes,
That
please
may
read.
be applicable.
Please read.
No workman who is employed in any industrial establishment shall go on a strike in breach of a contract, and no employer of any such workman shall declare a lockout. What is that? during the pendency of a conciliation proceeding before the board. The board has not intervened in this matter.
Hmm.
It is candidly argued by my friend, and he has also make a report that the board has not intervened in this matter. Proceeding before a board and 7 days after the conclusion of such proceeding. Now, otherwise, Lord, it was also pointed out by your lordship that had it been a case of public utility service, then the conciliation officers have the right. Your lordship has rightly pointed out. If your lordship goes to section 22, during the subclause D,
Yes, yes, indeed.
during the pendency of any conciliation proceeding before the conciliation officer and 7 days after the conclusion of such proceeding. So what is the power of the conciliation officer that has been inscribed under section 12? Should I read it?
No, not required.
I don't think I need not read it.
Not required.
Now let us come to section 23. Achha. During the pendency of a conciliation proceeding before the board and 7 days after the conciliation proceeding of such proceeding. During the pendency of proceeding before a labor court, tribunal, or any 2 months after the conclusion. During the next to BB, during the pendency of an arbitration proceeding.
Not there, not required.
Not required, section 10, capital A.
Hmm.
Achha. During any period in which settlement or award in operation in respect of any matters covered by the settlement or the award. So there is no such settlement, there is no such award which is covering this thing. So the conclusion of the learned presiding officer.
See,
Yes, Lord.
23, the regards or whatever restriction or conditions precedent is laid down in 23 applies to both you as well as to the management.
Yes,
So for a strike, the workmen, so far as a lockout, the management.
yes, yes.
Mr. Tiwari's argument, so far as there is no pendency of a conciliation proceeding before the
By a
board,
board.
would be say, also applicable to you. You can
Yes,
also take up the same argument
Yes,
that
yes, yes.
my strike cannot be declared illegal because there was no conciliation proceeding before a board.
By, yes, yes. Correct.
Yes, but his argument was only to justify that the lockout was not in contravention with 23A because there was no conciliation proceeding before the board.
Yes.
Equally, it will apply to you.
Yes,
No, let us be very fair. But how do you overcome the C?
See, yes, let us come to the
C is the only clause.
during the period in which a settlement or award in operation.
Yes,
Yes,
there
very
is a
simple.
settlement.
This settlement is this 21 that I have read it out.
Yes. Now, the 23 subsection C is unconditional. It
Yes.
is not qualified by anything else. It
Oh.
only says that during any period in which a settlement
Or
or award
award in
is
operation.
in operation.
Yes, yes, very simple.
Now, there was a settlement which
There
was in
was a
operation.
settlement. This settlement is with regard to the NPC. We have to carry out these things. And only after carrying out this NPC norm, our bonus was disbursed.
No, not only bonus.
Some other things, again?
There are relevant things also.
Yes, 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 yes. Simple case, my lord.
We come to that exhibit 21.
Yes. Just now I have read it out. Let us read it again.
Yes. Only the relevant part. I'll just
Page 117.
yes.
Clause 6, 7, 8 has no relevance,
6, 7, 8 is not.
relevant.
We have to examine clause 4.
Clause
4.
yes, the union and management agreed to work together. There is no difference. Work together for the growth of the company. No problem. Definitely union will growth of the company. In case of any dispute, it shall be sorted out through bilateral discussion. So our case was that you should not introduce contract labor. This much. Management agreed to introduce, we also agreed to introduce contract labor in clean tech. We have made a regulation that if you introduce contract labor to other section, then we may go for a strike. What the harm of it? I have a right to resort a strike. Only thing is that my strike should not go against the provisions of a settlement. Is there anything which management can demand me to raise an industrial dispute? Let us forget all these things, whether it is an unfair labor practice or all these things. Rightly or wrongly, we raise a dispute that you should not introduce contract labor in the establishment. Management agreed with that they will introduce contract labor in the clean section. Then our case is that despite of this fact, you have introduced some other section. And if you go on this thing, then we will go for a strike. Now, whether this strike will be illegal or not. So, Your Lordship, if some more clarification is required, Your Lordship may give you one more.
Not required.
I
Twen-
can answer it.
23 does not contemplate any prior notice,
Yes,
unlike 22.
yes. No notice is required. 22, yes, contemplate. If it is a public utility
Public
service,
utility, then notice.
then they say if it is an electricity board or well
Water supply
refinery
or water supply or
or water
essential
supply
services.
or well refinery,
Mm.
then we have to comply with certain provisions. 14 days.
And if the aspect of notice is not there, then the aspect of pendency of a conciliation proceedings before a conciliation officer will come in. In 23.
Yeah, that is
22.
that. No, yes, come and that conciliation officer will be guided by the provisions of section 12.
Correct. 23 does not contemplate regarding issuance of any prior notice.
Yes.
It only says that it should not be during the pendency and conciliation before a board, which is not there.
And
During
it
the
is-
pendency
that is
proceeding for
during the
labor code,
operation
not
of a
there. Pendency
settlement
for
or
arbitration,
award.
not there. Only thing is that 23C is the only provision which may come into the aid. You say that there is no terms of the award of the settlement in respect of which this matter has arisen.
Yes.
That is your case. Because
No, I was always against the introduction of the contract labors,
during-
rightly or wrongly.
During any period in which the settlement of is in operation in respect of any.
My demand may be unjustified, that is different thing. But we firmly believe that contract labor should not be
Contract.
introduced.
Okay.
This is my contention.
Okay.
Now the finding of the learned presiding officer that we resorted to an illegal strike, how it can? Only on two contemporary conditions. One is during the pendency of a conciliation process. Had it been a public utility service, probably the conciliation officer proceeding initiated by a conciliation officer would have some bearing. But this is not a public utility service. One thing that I am repeatedly urging before your lordship that strike may be unjustified. But that does not mean that strike is illegal. I may do something which I should not do. Or the management has done something that they shouldn't have done. But when there is a mandatory provisions, nobody should violate this provision. The learned presiding officer was of the view that we had resorted to a strike. Well, let me assume that we have resorted to a strike, and that strike is illegal. And as we have resorted to an illegal strike, they accrued a right to resort a lockout. A lockout may be unjustified, a lockout may be illegal.
What is the meaning of the term in breach of contract? Contract is the contract of employment, isn't it? Not the contract which is a part of the settlement. If you read 23, 23.
Yes,
the-
Lord.
This contract is only applicable to a workman. It is not applicable for the employer. So just read, no workman. Please read.
No workman who is employed in any establishment,
Industrial
Shall-
establishment.
sorry, in industrial go on strike in breach of contract.
Which is this contract? Contract of employment, definitely.
Let us come to the definition of settlement.
No. What is the meaning of the it has not said settlement. It is said in breach of contract. It is the contract of employment. How are your contractual relationship of the employer and the employee?
No, if you will also come to the definition of settlement, that will clarify the condition.
Okay, let us see.
Yes, you are also
PP.
2P.
P.
Yes, yes.
Yes, please.
Yes, written agreement. Written agreement is a contract.
Contract is
A
the
settlement means a settlement arrived in the course of conciliation proceeding. It may be arrived at the conciliation proceeding.
Yes.
And it includes a written agreement.
yes.
Written agreement between the employer and the workman arrived at otherwise than in course of conciliation proceeding. So, my lord, a contract may be arrived between the workman and the employer at the intervention of the conciliation
I do
officer.
not think this expression contract has anything to do with the definition of
Yeah,
settlement.
I shall check it up.
This contract is the contract of your relationship with the management.
I shall check it up.
Please-
Definitely, your
please-
lordship raise a new point.
Please read again. Please let us read again. No workman, 23.
Yes, definitely, you shall clarify this thing. We shall try to clarify. 23 clause 3.
No, first, the starting.
No workman who is employed in any industrial establishment shall go on strike in breach of contract.
In breach of contract.
Contract.
It is the contract of
so-
relationship between the parties,
Party.
contractual relationship.
Contractual
There is no
relationship.
other meaning.
No other meaning.
And no employer of any such workman shall declare a lockout. See, so far as the employer is concerned, that restriction of the contractual obligation will not come.
Madam.
It is a general embargo that you cannot declare a lockout. During what are the embargo?
I'm much
There are four
I'm much
conditions.
obliged by your lordship's inquiry, my lord. Of course, I have not thought of it, as your lordship pointed out.
No, there are four conditions under which it can be declared illegal.
Illegal.
Okay, number one is the during the pendency of a conciliation proceeding before a board not applicable, there is no.
No.
Number two is pendency before labor court tribunal not applicable.
Hmm.
During the pendency of arbitration proceedings not applicable.
Hmm.
During any period where the settlement or
Settlement is
award
there.
is in operation.
Hmm.
In respect,
Ah.
see, this is important. See, only the
In
operation
respect of any matters covered by the settlement
or
or the award.
award.
So whether this is a matter which is covered by that settlement, that has to be examined. If it is not covered by that settlement, then you cannot declare it is an illegal strike. You must say it is unjustified strike. Undoubtedly, it is up to the subjective opinion of the presiding officer. That for every case, you should not resort to a strike. You should have a conciliatory approach. That may be his view.
What is the basis or reasoning given by the learned labor court to declare the strike as illegal?
Or, according to him, no conciliation proceeding was pending. Undoubtedly.
Oh.
Strike is illegal. He has made no reasonable order. Look. I'm just coming to it. Page 27. I find force on
Yes.
what basis? I find force on the submission of the learned senior advocate. In present case, the workmen resorted a lightning strike. From 27/11/2007 and continued with that even after the repeated request of the management. Management requested us, you should not go with the strike. And labor officer to desist him from it. So as per my senior friend's argument, that the labor officer has no role to play.
That lockout in the premises was legal.
They hurled stones, bricks towards the clean area, abused management staff, slogan, etc., unparliamentary words, threatened the management staff to burn earlier, etc. These are the factors. Now, as per section 24(3),
That is okay, 24(3) is okay.
industrial is full lockout.
The next line is okay, also okay. Therefore, I'm of the opinion lockout in the premises was legal. Then thereafter, the next line, this is having little bit of issue. Since the strike is illegal,
Yes,
where is the basis?
that is not clear.
To
Strike
be,
may be illegal. Strike may be illegal if it is
only if in contravention with,
the settlement.
it's, if it falls within the meaning of 24.
Yes,
24 says that what strikes and what lockouts will be illegal. Those will be illegal which are in contravention with 22 and 23.
yes. So far 22 is concerned, is not
It's
applicable.
not applicable.
So
23,
23
the
is
only
applicable.
clause is the last clause.
Uh,
Where is the discussion?
no, nothing. At least I have not found any discussion. Subject to what my friend pointed out. Now, paragraph 12, although the witness of the union, the Govinda Kalita, in his evidence in affidavit stated that workmen never resorted to illegal strike. Yeah, all right. Let me assume that we have resorted to strike, illegal strike. In paragraph 7 of the written statement, the union admitted that from 27/11/2007, they took the path of additional program. Let me assume that you took a path of the resorting a strike instead of educational program. Let me assume this thing.
No,
From
Mr.
exhibit
Dasgupta, one thing is very clear from 22 and 23. There is a vast distinction between a public utility
Yes,
service and any other
other issues.
any
Public utility
other industrial establishment.
No,
And resorting to strike per se will not be illegal.
illegal.
It would be illegal if it is in contravention with either 22 or 23, as has been held by 24.
Yes.
24 says illegal strikes and illegal lockouts.
Yes.
Same parameters will also be applicable for a lockout.
Yeah.
Either the whatever the condition laid down in 22, so far as public utility service, and 23, so far as industrial establishment are concerned, if those are met, then it can be declared as illegal.
Illegal.
Either a strike or a lockout,
Okay.
otherwise not.
Hmm.
Simply resorting to strike may not be illegal per se. As you have said, maybe rightly, it may be justified, it may not be justified,
Yeah,
but
it
to
may be
have,
unjustified.
to be illegal, it should come within the parameters
But-
of law.
It may be unjustified.
Okay, okay. Okay, I think you're clear. We'll just have a clarification from Mr. Tiwari and close this.
But this was not argued earlier. That's why, my lord, I'll clarify this.
No, no, see, these are points of law. In fact,
Correct.
we,
No, no,
we,
you are everybody.
we triggered this question and we need to be,
No, I am very much obliged. You know,
We need
your-
to be
your lordship
clear
has
on certain
pointed to
aspects.
some things which I had not thought of it. So first,
okay.
section 23 is concerned. I am much
Okay,
obliged. to your
yes, we'll close this. Madam, which matter are you waiting for? Today we may not have time, and today we'll have to rise early because of some other. We'll have matter of which year? 16, then we can have, we can try day after tomorrow if it's not inconvenient for you, or next Tuesday.
My lord, in fact, in this very case, now I am being told that now they may like to engage me in this case.
Which one? The
The
next
other
matter.
matter,
Okay.
this very particular case.
Okay.
My lord, let me receive material instruction and thereafter, my lord, let me at least prepare the case. I
That-
need some time.
Will not be an obstacle on your receiving the material instructions.
So both the aspects are equally relevant. So, my lord, my lord.
I think
that's
one week is good enough to have
Lord,
your
Put
material.
it be on 19th
material
of March. My lord, put it be on
Message-
19th of March.
Nowadays, it's a matter of 1 minute or 2
Put it be
minutes
on 19th of March.
Nowadays,
online.
night is matter of 1 second.
1 second.
19th of March, my lord. At
Okay.
least I like to go through everything and prepare the case
One
properly.
page.
19th, 16 matter, I think. Is it, 19th?
19th March, no adjournment, I'll finish it.
Mr. Tiwari doesn't need 1 week to prepare a case.
My lord, but there are other engagements. I may have to go to, my lord,
You're
outlying bench.
not going anywhere.
My lord, outlying bench, my lord, there would be
We
a
know,
problem.
we know your schedule. You're here this week.
My lord, there is some.
Okay,
problem.
19th.
My lord, please.
19th.
19th.
Yes, 19th is okay. Today is 5th. Oh, 19th, 2 weeks. No, not 19th.
My lord.
We have it next week, next
my lord,
14th.
Actually,
14th.
my lord, let me just see, my lord, those.
These are old matters, doesn't look good.
14th.
17th is Sunday. 17 matters.
2017.
17 matters doesn't make any difference. 16 and 17, 5 years.
7 years.
More than
My
5
lord,
years.
there is a part of cases of that.
Tell us a date.
That's why. my
We
lord,
give you
14th,
11th, we give you
my lord,
13th.
18th, my lord, the chief justice has fixed the case. 14th, there is a part matter. 18th, my lord, the chief justice has fixed the case in court number 1. That's why, my lord, 19th.
Okay, 19th. Madam, 19th is okay for you? Positive, paucity of time did not allow the matter to be taken up.
It may be 25, 26, Malay edited
Full stop.
on 26.
On the request of the learned counsel for the parties. List on, yes, give us an agreed date, 25th. 25th is a holiday, madam.
25th Monday, Malay. It may be
Holiday.
26th.
26th also holiday.
maybe.
I said holy day, not say holiday.
28 might.
Holy day.
19th production idea, not the difficult.
Holiday for holy.
19th production idea.
No, 19 we have to do.
Then we'll fix a date. You cannot say no, either if you, no, none of you can say
It
no.
may not be on
If you
19th.
have to have a problem on all the
Let
dates,
my lord fix a date.
It may not be on 19th.
Same.
okay,
court date.
27, 21st,
My lord,
21st. 21st.
All right.
21,
All right.
21.
Better, better, better.
The old matters, don't seek
21st,
adjournment, we'll
21st.
finish it off.
21st.
Just conclude your arguments in 10 minutes. This one we have to raise earlier
Yes.
today. Okay.
21st. Thank you. My lord, there are two facets. First of all, legal or illegal. My esteemed colleague will have to overcome another hurdle because the relief they were seeking was before the London Labour Court, back wages for the period of strike in the lockout. Now, so far as the back wages part is concerned, it is barred by a subsequent settlement also, which is binding on them. How will they overcome that? Finally, the London Labour Court held, regardless of all other aspects, the very settlement, namely the settlement dated 23rd July 2008, Exhibit 42,
Yeah.
which specifically provides no back wages for the period of lockout and strike, is binding on them. So they cannot claim back wages. So, my lord, this is the hurdle they could not overcome. Because this is the relief they were seeking from London Labour Court. This was the reference, namely the back wages. And the settlement prevents it, which is entered into by the union and the manager. So this settlement is binding and it covers exactly the core issue. That's my first submission.
You please continue. Just sit
So
there.
this is my first submission. Now my second submission is, though it is true, London Labour Court has not given any specific reason as to why this strike is illegal. But you know, if the reasons can be deciphered from the materials available before us.
Mr. Tiwari, though this would be a very technical kind of, we have not concluded, but this is inevitable because neither the Labour Court nor this court it's not an appellate court, as you know. We are just having a supervisory kind of a look on an award of the Labour Court. We will not enter into everything. And we definitely cannot go beyond the scope of the reference. That is the basic foundation of an award in a Labour Court. Mr. Dasgupta, with all humility, I think the reference was not properly structured.
Yes, that's the problem.
The legality or illegality of the strike or the lockout was not even the issue. That is, I think, one
That
of
was
the.
another facet of
In fact, this is
That is a very easy question. though. I'm just-
No, these are in fact not very.
We are
These
equal
are
of-
unhappy situations. In fact, this should have been one of the questions.
No, yeah, that can be answered right now. If your lordship go through section 10(4).
10-4, yes.
Yes, the very
10(4).
easy question, Lord.
10-4. Let us see 10-4.
Incidental, that too.
Incidental.
Yes. That's a very easy question, Lord.
Incidental there too will cover what, Mr. Dasgupta? 10-4 has been discussed in a number of cases.
Yes, I will rely upon this thing. Otherwise, what is the utility of making this happen?
No, this is a very, very specific question whether a lockout or a strike is illegal. That's a different aspect altogether. You're only seeking back wages for a particular period.
Yes, if the lockout is illegal.
No. The question of legality of the lockout is a specific question. There has to be a reference. In fact, see, Mr. Dasgupta, the corollary could have been a better thing, that the legality of the lockout was the question, moot question, and therefore as a coincidental or an incidental issue, back wages.
Automatically, back wages come into play.
Automatic, but back wages, declaration of back wages will not take us to the root question of holding or declaring the lockout or.
No.
Yes.
That is, we are totally
And
wrong.
legality of settlement also belong. Subsequent settlement.
My lord,
Exhibit 42.
this matter was decided long back in the year 1960s.
Which one?
So far, the question of examining the issues as
Incidental.
contentious incidental.
Which one? Socklighting, which one?
Delhi Cloth Mills case,
DCM.
DCM cloth. It is settled in the year 1966. I will place this judgment. What is that? what is the issue before the labor court or the tribunal, as the case may be, that has to be understood by going to the respective pleadings. I will refer to them if required.
No, please do. Because that will be a.
That is it is settled long back. And this case was referred, I'm just giving 2008 ONGC's case, page 275, 2008 SCC. Page number is, you can remember, 275 per volume I can. Teacher, ONGC, 2008, probably 4 SCC or something like that. Page number I remember, 275. Here, this DCM case was examined. And it was yes, sometime it may be so happen that the terms of reference is cryptic. It cannot be. But for that purpose, the court has to go through the respective things. And another judgment that was delivered by Honorable Justice Ranjan Gogoi, he has given more details.
Name.
But right now I can't keep the name, but the judgment is with me. But unfortunately, this judgment was not reported. But I will refer this Delhi Clock Mills judgment.
We have to read we have to examine the facts.
Hmm.
See, incidental issue is something which follows consequence.
Yes.
But it cannot be reverse.
So this is not
While
a,
deciding the question of.
This is not a new issue.
No, this was
Now,
not
what is the corrigendum?
Mr.
Let me finish this.
Corrigendum we have read. Corrigendum is nothing, it's only specifying the period.
Oh, yes. So if the lockout is illegal.
No, where do you get?
No. A lockout was resolved. And it was agreed that whether this lockout is legal or illegal, that will be adjudicated by the adjudicating authority.
That was not even the terms of reference, unfortunately.
No, that is unfortunate.
It was
That is
there was a corrigendum also.
No, you must clause 4.
No, 4.
Very much clear.
Yes, 4 we have seen.
All right. So what is the dispute between the parties? The matter is intended to them by referring further adjudication for the appropriate authorities. So if there is any dispute, it must be referred to the adjudicating authority.
Yes.
So what was the dispute? So whether we are entitled to have the back wages or wages. Because it was agreed that agreed is the principle that no work, no pay would apply. However, the strike and lockout is justified, unjustified, legal or illegal, being disputed between the parties. The matter was intended by them to be referred further adjudication. So whether it is a lockout is justified, whether lockout is illegal, that has to be adjudicated by the adjudicating authority. Now your lordship's question is that while making a reference, there should have a clear indication to the effect whether the lockout is.
No, see, the reference code would deal with which issue? The labor code before whom a reference is made by the appropriate government will deal only with the issue which has been referred to.
Yes. No. They can go to the terms which are incidental.
Incidental is what?
Incidental which
arises as a consequence of this.
Yes.
Now to decide the issue of non-payment of back wages, if you are entitled to go
otherwise the reference is totally meaningless. If we have to go by this analogy, then the reference is totally illegal, totally meaningless.
It appears so.
No, it appears so.
It appears
so. So we have to resolve these things.
Okay, we'll do one thing. We'll continue this for some maximum half an hour tomorrow, only on the issue of incidental thing. Otherwise, hearing is almost complete. First item tomorrow. You come with DCM case and
Right now I can give it.
No, tomorrow we'll have it. Today we'll have to rise early. First item tomorrow.
Let it be there for tomorrow, Milord.
No, no, tomorrow we'll complete it. Or we can have it at 2 o'clock also, no, tomorrow, no issue. You have some difficulty in the first half, we can have it at 12 o'clock, 2 o'clock,
All right.
10:30 tomorrow. Only
no,
to,
Later tomorrow.
tomorrow, what is the problem?
Oh, I have a big case in report number 2.
At 2 o'clock, we'll have it, only the decisions you need to place. We have heard you. Tomorrow we'll close it, 2 o'clock.
And another aspect they have to overcome, the exhibit 42 settlement also,
Yes.
because what they are seeking is
No, the 10-4, to be very frank, that is why we are trying to, we'll have more, some assistance tomorrow from Dasgupta. To 10-4, this court is not very satisfied. Incidental will not mean something which will go to another issue which is independent in nature.
I'm going beyond 10-4. I'm going beyond 10-4. Assuming for a moment,
But
that
still then, let
comes
us
to the
be
aid of
fair,
my esteemed colleague.
let us be fair to Mr. Dasgupta. If he wants to show a decision, it may have some effect also.
And but my lord, I'll be arguing that even if 10-4 comes to the aid of my esteemed colleague, even then,
No,
so even if the 10-4 comes to the aid of my esteemed colleague, even then, my lord, the award of London Labour Court will sustain for the simple reason, what they were seeking is the difference was your back wages. Now, this was the reference. And the London Labour Court finally held that because of Exhibit 42, the subsequent settlement, not the earlier one, subsequent settlement is binding on them. Since subsequent settlement is binding on them, and that settlement said no work, no pay for the period of lockout and strike, the matter is over.
No. All right. No, Milord, may I ask one question?
Yes, please,
What
please.
is your lordship question with regard to subsection 4 of section 10?
Yes.
May I read it?
Yes, sir. We'll have it tomorrow. You said DCM will explain 10-4.
Tomorrow, or day after?
Tomorrow.
Tomorrow. Tomorrow.
Yeah, but tomorrow it will be, I have to start it out this then.
Your junior is there nowadays. You had said 1 button. If material instructions can be given in 1 button,
No,
Yeah.
material instruction can be given, but for the material.
this needs half a button. With today's AI, nothing is needed. And you just know everything. You know the page number also. Just sit for half an hour, everything will be done.
Page number is 275.
Tomorrow at 10:30. Hearing,
Huh?
the hearing remains.
Well, let me at 2.
Okay, 2 o'clock. Hearing remains unconcluded. Full stop. List as part heard tomorrow. You come at 2 o'clock. We'll accommodate you.